The prayer of the written became interruption. May I pray?
Yes.
My lord, item 22 kindly taken for answer.
Yes.
Item 49. Today this matter proceeds for the consideration of interim order. Consideration of interim order. It may not reach, I pray.
Oh, wait. Yes.
Item 41, madam. Item 41. There is a noting that counter not received, but I have filed counter upload.
You are for whom?
I'm to the AP, madam.
Which for the petitioner?
Petitioner, Mr. Mishra.
Have you served a copy of your counter affidavit?
My lord, mine. All right, sir. 41.
41. 41, Mr. Mishra is there.
Married. Of copy alert, sir. There is a noting counter not received. By
Not received means you that might not have been tagged to.
Verbatim counter filed drug 10, but in case
The first item, the counter affidavit has already been filed.
nine already been.
What do you say?
Yes, my lord. I have
Have you received the copy?
Yes, my lord.
So, do you intend to file any rejoinder?
Yes.
Or you have to decide?
No, my lord.
So, let it go to after vacation.
Yes.
Puja holidays.
Yes.
Sorry, summer, 6 months holiday. WPC number 13029 of 2025. The London Council appearing for opposite party or parties?
Opposite party, so
Sole opposite party submits that he has already filed the counter affidavit and a copy has been served on Mr. Vibhuti Bhushan Mishra and Senior Panel Council Union of India, which is not disputed by Mr. Mishra. However, the counter affidavit is not placed on record. Let the registry place the same on record stock. Mr. Mishra, so far, Land Council for the petitioner submits that intends to file a rejoinder affidavit to the counter, and the matter may be taken up after ensuing Xmas holidays. It is this matter, second wicket of month.
But the interim order is
Interim order is there.
Yes, sir.
Interim order dated so and so, passed in IN number so and so, shall continue to next date, and this matter is to be listed with WPC number so and so. Yes.
My lord, item 22 kindly taken up after vacation.
Why? Why after vacation?
My senior is ill, madam.
Who is your senior?
Srikar Kumar Ratha.
Huh?
Srikar Kumar Ratha.
I am appealing for the petition.
You are for the petition. Any objection?
Oh.
I am not.
Any objection?
No.
You are Mr. Nishit Kumar Mishra.
Ajay Kumar on behalf of NK Mr. Senior Narendra Krishna.
A. Mishra. You are Mr. A. Mishra.
A.K. Roy.
A.K. Roy, actually. Madam Purnani, appearing on behalf of the opposite party, submitted that her senior, Mr. So and so, is not here, and the matter may be taken up from out of the Mr. A.K. Roy, Line Council for the petitioner has no objection to such prayer for adjournment after Xmas holidays. Yes.
May permit me, item 6 and for the two for the two opposite party, but I filed a preliminary objection affidavit maintainability because he has filed a three challenging the three original application was filed a single order. So maintainability I have to file an objection.
Common order.
Even if common order, according to me,
What do you want?
file a preliminary objection with affidavit, not maintainability.
No, why are you not filing? You want time or what?
Yes, one.
You are for the
I am for the opposite party number.
How many opposite parties are there?
That's
Private opposite parties.
that one sole opposite party? No, there are number of
Yes, yes, my lord. The three original applications.
there are as many
My
as
lord, I am for the one and two, my lord.
who is appearing for the other opposite parties.
Of this.
There are 7 opposite parties as it appears.
Only for one and two, my one brother one and
So, what about the others? Notice has been issued or
Service is complete.
matter. Share your worship directed to file the original copy of the original application which has been filed before the CAT. I have already.
Oh,
the
he-
notice.
Has not.
he was the cavator.
Yes,
He
I am
is the
the
curator.
So that is how. Wait, we will take up this matter and decide whether the notice has to be issued at all or not. Yes.
Yes.
Okay.
Your Lordship, item 48. I've been just engaged today morning. Can it be taken up tomorrow or day after? Item 48. I'm for the petitioner, my lord. This is regarding the auction of a cold storage. So because certain other developments have taken place in between. So I would just like to file an additional affidavit and a rejoinder if required. And can the matter be taken up on Thursday or Friday?
48.
Yes, my lord. WPC 32998. Biraja Cold Storage.
Mr. Acharya and senior advocate submits that he has instruction to appear for the petitioner and the matter may be taken up. On what date you want, Mr. Acharya?
Thursday or Friday is fine, my lord. 18th or 19th.
Matter may be taken up on some other day of this week. Where is Mr. Ranjit Sahu? He is not there. All right, please this matter on 19th of December 2025.
Grateful. In the meantime, I may be permitted to file a rejoinder also.
And the petitioner is at liberty to file the rejoinder affidavit filed to the counter filed by the opposite party number 3. Yes.
Grateful.
Weekly daily. First up, item number 1.
I've already filed the requisites along with the money receipt of the
20,000 rupees. Lost person. Where the receipt?
requisites and money receipt.
When you file the requisites?
My lord, on 10th.
On 10th?
Yes.
Service return has come.
No, my lord.
AD
Noting
not
shows that it has not yet returned.
Okay. 10th one as you know. 15th. This is 20,000 rupees.
Yes.
The land council for the. You have filed or you are just filing? A group
File for this. Noting also shows that I have already filed.
As for the order dated 10/12/2025, land council for the petition has filed, has deposited this 20,000 in the High Court Advocates Welfare Fund, and receipt to that effect has already been filed, which is on record. He further submits that as for the said order, he has also filed the requisites for the notice to the legal heirs of the deceased respondents number 5207 or 567. So, however, it appears that neither the AD nor the undelivered pieces issued to the so and so as returned. is this matter secondly being represented? The registration bills in AD or on delivered notice issued to the prostrate parties and if any land council enters appearance for the state parties, the names of the land council be reflected in the course. Yes, next.
Item 2.
Please.
We have filed the consolidated petition. In this petition matter, the petitioner challenge the order passed by the Learned Tribunal on the annexed female dated 25/4/2024 part in OA number 161 of 2017.
Annexure 3. Annexure 3 is that.
Annexure 3 is the important order. Prior to that matter, the applicant who is alleged as married opposite party, he has approached before the tribunal in OA number 153 of 1997.
So you come to your prayer. That means the relief short. That is page number 40. Here,
page number 12.
Relief sought for original application paragraph number 8. You want to know what was your prayer?
Yes, ma'am. To quash the order dated order of respondent number 2 dated 30/8/2016 under Annex by 16 and direct the respondent number 1 and 2 to antedate the date of regulation of service of the applicant, date of his absorption in Group D service from the date retrenched casual laborers of RRB Bhubaneswar as are seen under Annex by 3, who were similarly situated like him have been regularized and observed in the service in terms of Annex by 2 with all consequential benefits including pensionary benefits on the basis of equality and maintaining uniformity in consideration or quality. Annex 16 and direct the respondent number 1 and 2 to treat the date of incorporation of the name of the applicant in casual leave register, that is 8/3/2002 on as has been made under Annex A by 6 as his date of appointment as substitute helper 2, which has been made Annex 7.
So that was other prayers are there. That was made by the opposite party before the tribunal.
Yes.
And you filed the counter affidavit. And what is the order passing to know?
And as per the order of the tribunal manner, during hearing the applicant did not press for regularization. He only submitted that my name be entered to the.
Come to page 99, para 5.
5.
Para 5. Read it.
19. In the instant case, it is not in dispute that the persons, those who were regularized by order dated 12/8/1993, were all were engaged as casual laborers in the years 1991, 92, and 93, whereas the engagement of the applicant on such casual basis was 1986 on perusal of the order of the High Court of Orissa in OJC number circumstances dated 11/9/2000. It is established that the Honorable High Court dispose of the petition holding that in view of the letter dated 6/1/1992, no further direction is necessary. Therefore, when the case of other casual laborers who were engaged in 1991, 92, 93 and retrenched were considered and regularized, the respondents ought to have been considered in the case of the applicant since his engagement and retrenchment were much prior to 1991. Further, when the case of the applicant was taken to live casual register and subsequently he was engaged as substitute conferred with temporary status and regulation, the respondent not to have been taken note of the order it is second. All things have been done. The order dated 12/8/1993 A by 3, wherein the juniors of the applicant were regularized. Thus, there was miscarriage of justice caused to the applicant in the decision-making process of the matter is telltale on the face of record. The respondent did not utter a single word in respect of the above aspects in their counter and have only raised technical objection of limitation, etc. This tribunal is not impressed on such technical grounds when the injustice is culpable. The corollary of the discussion made above, it is held that the grievance of the applicant needs favorable consideration at the hands of the respondent authorities. The impugned order dated 38/2016 under Annex A by 6 is hereby passed. The respondents are directed to consider the case of the applicant for regularization from the date when others were regularized, while the order dated 12/8/1990. However, without any backwardness and consequential order to be issued to the above effect within a period of 120 days of the receipt of a copy of this order. In result, the OA stands allowed in the extent stated above, however, leaving the parties to bear their own cost. As per the when first order was passed in OA 153 of 993, the opposite parties came before the Honorable and the Honorable Court as per the order passed by the personal officer did not want to pass any order in that PJC and accordingly disposed of to comply the tribunal's order. And as per the order, pursuant to this Honorable Court's order, the applicant was conferred temporary status, so also subsequently regularized in his service manner. And what happened actually, he now wants that his appointment should be antedated. As it is manner as he was engaged and disengaged at the period, the date on which he wants to be antedated, he was at that time was a casual labor.
The others were also there. The other person.
The others were continuing and retained. He was retained.
It is clearly stated that in casual labors in the year 1991, 92 and 93,
Yes.
they were also similarly, they were disengaged and again they have been taken back and their cases have been regularized like the petitioner. Petitioner is 1986. So what is the difference between the, why he will be, that is the reason which has been assigned that why his case be left out from the zone of
at that juncture, he was granted temporary status on 5/8/2006. Unless until he was granted temporary status, he could not be regularized.
All these things you are telling now, in the counter you have not said anything. That's what the tribunal says. Counter only one point, res judicata and limitation.
That he has approached after 18 years.
So whatever, that is now, Article 14 says that merely because he approached late, you can't done away with his right.
No, that is
once the order has been passed, it is your responsibility that if similarly situated persons are there, you should, as an ideal employer, you should do the needful and regularize all these cases. Not that each individual should come and approach and then that would linger and they would.
And the reasoning is done in para 4. The argument which you are advancing, that has been very clearly dealt with para 4, Article 14 and everything. What my learned brother has said. These things have been dealt with.
Yeah, that's why I'm telling you. What happened actually? Till that date, he was not confined to temporary status. Unless until
serving in 1986.
Yes, I bowed down for you. But what happened actually? Unless until a casual labor is conferred with temporary status, he could not be regularized. So in the year,
What is the great loss causing to Union of India, regularizing one single person?
Back wage, nothing was
litigating
just,
everywhere.
If you would have been given any back wages, clearly stated that no back wage, nothing.
You say that we will not litigate We are ideal employer, and for one regularization of a casual labor, you come up to High Court, then you'll go to Supreme Court. This is the policy you are following.
The petitioners approached this court challenging the order passed by the Land and Central Administrative Tribunal Cutter Bench Cutter in OA number 260/00161 of 2017, or dated for them to 24 or 25 for 2014. In allowing the original application stop, it appears that the opposite party was the applicant in the aforesaid way, and his prayer before the London Tribunal was as follows. Quote paragraph number 8. The main grounds that has been taken by the opposite party for claiming such relief was that the order dated 38/2016 was a non-speaking order, and it was silent on many aspects. We showed that the authority had not considered those aspects while passing the order. The order dated 38/2016 was passed rejecting the claim solely on the ground of limitation, which is a technical ground, and on the basis of it, the opposite party who has good case cannot be denied it. It is the further grounds have been taken by the opposite party that he had sought for antedating his date of regularization only to come under the fold of pension scheme. And in the impugned order dated 38/2016, nothing has been said by the authority about the similarly placed persons like the petitioner, who were earlier taken back to service and regularized in their respective posts with all consequential financial benefits. And that the factum of termination of the opposite party has not been denied by the petitioner. It is further stated in the grounds that the opposite party is neither claiming seniority nor financial benefits, bracket except notional benefits, while praying for antedating his date of regularization of service from 8/11/2007 to 9/7/2002 for the purpose of coming under the pension schemes. And the said aspect has not been considered by the petitioners while passing the impugned order dated 38/2016. Grounds have been further taken that there is nothing in the said order as to why the order of the London Tribunal dated 2/4/1998 passed in way number 153 of 1997 was not immediately complied with, and why the delay was made, and why the petitioners sat over the order, causing prejudice to the opposite party and delaying his regulation in service in the subsequent period. It is further stated that if the order of the London Central Administrative Tribunal would have been immediately complied with, the opposite party could have come under the pension scheme. So, it is the further case of the opposite party that having issued instruction to observe the retrenched casual labor of RRB or the BBS under Purda division. Later dated 6/1/1992 of the Chief Personnel Officer Administration. The petitioners as the opposite party should not have been discriminated in objection by the opposite party by the petitioner number one. Petitioner number one, when similarly placed retrenched casual laborers like him were re-engaged and observed in service. Grounds have been further taken that the petitioner number one is in observing the retrenched casual laborers by pick and choose vendor without considering the cases of all the retrenched casual laborers for their objection amount to unfairness and discrimination. It is further stated that the petitioner number one acted upon the order of the London Tribunal forthwith in including name in the live register of the casual laborers. His objection in Group D post would have been effected earlier, much prior to the cutoff date, that is 1/1/2004. And had it been so, he could have come under the provisions of pension scheme like other retrenched casual laborers who, in view of their earlier objection in Group D post prior to cutoff, have come under the fold of pension scheme and are getting more service benefits than the opposite party. Counter affidavit has been filed by the petitioners where grounds have been taken that the prayer of the petitioner, the prayer of the opposite party are hit by principle of limitation, and that the petitioner, that the opposite party has been informed by reason and a speaking order dated 30/2006, and that his related request for grant of antedating of regulation for his service with effect from 9/7/2002 instead of 8/11/2007 cannot be considered. The London Tribunal, in the impugned order, after taking into account the pleadings of both the parties and the contentions raised by the learned counsel, respective counsel, has been pleased to hold as follows. For paragraph number 5, 6, and 7. The learned counsel for the petitioners, the Mr. D.S. Ragurul and senior panel counsel, has reiterated the same contentions which were raised before the London Central Administrative Tribunal, and submitted that in view of the delayed approach of the opposite party in claiming the relief, he should not have been granted the relief. However, on those aspects, the Land Tribunal has dealt in the impugned order, and admittedly, the casual laborers which were engaged in the year 1991, 92, and 93 their cases were and retrenched, and their cases were considered and they were regularized. And therefore, the petitioner, who was engaged as a casual laborer in the year 1986, even if he has been retrenched and his case was considered and he has been also regularized, he should he should have been regularized when the others were regularized, who are his juniors, which has not been done, and therefore we find no illegality or infirmity in the order of the Land Tribunal in directing the petitioners to consider the case of the opposite party for regularization from the date when others were regularized by the order dated 12/8/1993. And more particularly when the London Tribunal has stated that such decision has to be taken and orders will be passed, and that too without back wages, and the approach of the petitioners to this court against the impugned order is not at all acceptable. And
120 days since the complaint, without it will give days.
It seems that when the impugned order was passed on 25/4/2024, only 120 days time was granted to take the necessary steps in that regard. And admittedly, the said period has expired. However, since we are dismissing the writ petition filed by the petitioners challenging the impugned order of the London Tribunal, we direct that the petitioners shall comply the order of the London Tribunal within a period of 60 days from today, and failing which, open to the opposite parties to take steps in accordance with law.
90 days.
Why 90 days? 1 year back, this order was passed. More than
20 दिन आपण थिला जे ऑर्डर पास ହେଇଥିଲା ଆପଣଙ୍କର 25/4/2024 ରେ
Pending thila.
ହଁ କଣ ଗରିବ ଲୋକଡାଙ୍କୁ ଏମିତି ଆଉ ଇଏ
And another thing is that one, kindly have a glance to page
next yes based on this
12/8/93 from the
yes item number 3.
Item 3.
And 90 days have gone.
Item number 3, Mr. Sahoo.
Item number 3, my lord. Petitioner challenging
To obtain inspection in the matter and to file affidavit as well the previous. Yes.
state affidavit not filed by OP number 1 and 2.
Very good.
And I am the petitioner.
You are for Tunasa?
I'm for the petitioner, my lord.
No, who is for the Tunasa, Mr. Tunasa? He appeared for Indian Bank on that day. You are an associate of Mr. Tunasa?
No, I am the petitioner.
All right. Any development made in the meantime?
No.
No.
Call him. Call Mr. Nasa.
We are just passing it over. Please call him.
Call him.
Huh? Next.
Item 4.
Item 4, may I please your lordship. Petitioner being aggrieved, the order dated 22/7/2025 that under annexure 16 for a direction to deposit an amount of rupees 2,65,93,917. Petitioner, fact of the case is that the late husband of the petitioner, Vijayalal, has availed a loan from the opposite parties, and at the time of availing loan, as part of the loan sanction, a group credit secure plus insurance policy was obtained from the opposite part number 2, that is.
Oh, yeah. 13-2 notice has been issued. SARFAESI Act 13-2 notice has been issued to you.
My lord.
So,
My
have
lord.
you filed your response?
My lord, I have categorically submitted because in relating to the loan availed after death of my husband who has availed a loan at annexure, immediately I submitted annexure 9, 13/8/2021 and prayed to settle the matter.
No, forget about what has happened in recently. The latest letter which you are producing before us. You see you file the response, your representation had annexure 15, which is addressed to the branch manager of LIC Housings, right? And in that letter, your prayer was request for extension of time for final settlement of loan.
My lord, I have deposited in that.
Just a minute. And therein in the page 47, you have stated that in light of the above, with bona fide intent, I honestly request a final extension of 6 to 8 months, at least on humanitarian ground, to enable me to arrange the balance amount and fulfill the obligation towards so and so. I assure you that that will be the last and final attempt, and I am committed so on. So this letter was issued, and obviously thereafter the bank considered that letter which was dated 24/6/2025, and there the bank has stated that as per so and so you are required to close your account so and so. You are informed to close your 2 loan accounts by paying an amount of rupees so and so on or before so and so. So we continue the so. What can we do?
Petitioner is not in a borrower. My lord, the
All
husband of
these
the
things you have
petitioner.
to tell in the appropriate forum.
And my lord, instead of settling the loan account pursuant to the policy under annexure 8,
all these things are on merit, sir. All these things are on
that
merit.
hasn't covered 1 code 23.
First of all, you have to maintain this writ petition. Then only we can get into the merits.
Approach the appropriate forum. From the petitioner has filed this writ petition. Inter alia challenging the letter dated 22/7/2025 of the opposite party number 1, wherein he has been informed to close his 2 loan accounts. That is loan account number লেখা আছে page 48 annexure 16. by paying an amount of rupees so and so, rupees 2 crores 65 lakhs 90 so and so on or before 31st July 2025 by so and so, failing which the petitioner, failing which the opposite party number one continue with the further action of under Surface Act 2000. Though many points have been urged before this court that such a notice is issuance of such notice is arbitrary and the action of the opposite party suffers from procedural impropriety and threatening given to the petitioner for taking recourse to Surface Act is wholly disproportionate and unjust. But in the factual scenario and in view of the law laid down in so and so, so and so, so when alternative remedy is available to the petitioner, it is open to the petitioner to seek such remedy. It is made clear that we have not expressed any opinion on the merits of the case. Hello, disposed of. Next.
Pardon, my lord. I'm extremely sorry, my lord. Item number 3.
Yeah.
My lord, some more time is required, my lord. As per
The
the
last.
yes, my lord. We have taken 2 more previous time, my lord, for filing the counter affidavit, my lord. The counter affidavit has
9/7/2025.
yes.
No, even prior to that also.
2/5/2025.
2/5/2025. You entered appearance and you
Extremely sorry, my lord.
14/5, then 9/7, then 19/9, then the last order perhaps is 24/10/2025.
Last
where it is said
opportunity, my
that Tuna Sahoo and Council appearing through so and so submit that some more time is required to obtain instruction in the matter and to file affidavit as per the previous order of this court.
This affidavit has not yet come, my lord. So
No,
last
then,
2
pay cost.
let it come after vacation, my lord.
Your bank, and why can't
They
you
pay
do it?
cost 20,000 in the High Court.
My lord, last
welfare.
opportunity.
No, you have
Last
already.
only. We are giving it subject to paying cost.
5 opportunity you have already availed. Now today, if you will give, this would be 6th ones. We are ready. We are getting it listed after ensuing Xmas holidays. You pay deposit 20,000, and you are after all a bank. Lekon.
My lord, last
Mr. Tuna
opportunity.
Sahoo
My
and
senior is
Council
out of state.
appearing for
We're
the
giving it.
one so 6 more time to obtain instruction in the matter and to file an affidavit as per the previous order of this court. Needless to say that Mr. Sahoo has entered appearance in this case on 2/5/2025, and thereafter the case was listed and got adjourned on 5 occasions, that is on 14/5/25, 9/7/25, 19/9/25, 24/10/2025, and on each occasion at the instance of Mr. Sahoo, the Land Council for the bank. Land Council submits that some more time may be granted, and this may be, you will not seek further time in the matter. In view of such submission, list this matter second week of subject to deposit of cost of rupees 20,000 in the High Court Advocates Welfare Fund. Receipt shall be produced on the next day.
My lord, last
Made
last
that
opportunity,
the
my lord.
amount is not deposited, the counter affidavit will not be accepted. Yes, next.
Item 5.
Madam, the petitioner approached the OARC under section 156 of the Electricity Act for non-compliance of the order of GRF. While deciding the
the learned ERC, without proceeding with the 146, what is directed for a settlement between the parties, and in absence of settlement, the GRF will revise the bill. The relevant annexer, the input order is annexer 4, page 74.
No, they have the panel council, I think the TPCODL or panel council.
TPCODL is there, OERC by notice.
TPCODL may not be a part.
TPCODL is a party.
SDO electrical TPCODL party achandi bra. And
OERC.
OERC.
OERC means thing that Mr. Abhishek Das used to appear for OERC.
But OERC regulatory body is not
Yes.
contesting is 2 and 3.
Yes.
Contesting is 2 and 3. That's regulatory body.
The order is passed by OERC, so he may not.
Therefore, OERC is not a police department.
So what has been done in this case? The prayer which is made,
My lord.
you are challenging the order dated 10/6/25.
My lord, that is annexer 4, page 74.
Yes.
My lord, before that, my lord, 146 of the Electricity Act. That is for the punishment for non-compliance of the order passed under this act.
No, you just come to paragraph number 8 of that
My lord.
particular order,
My lord.
which you are challenging, page number 75.
My lord. Having heard the parties and considering their submission, the respondent is directed to revisit its calculations made on revision of bills of the petitioner consumer in accordance with the directives of the learned GRF cutoff, and serve a copy of the same on the petitioner consumer within 7 days from the date of this order. Thereafter, the petitioner and the respondents may explore the possibility of an amicable settlement of the dispute pertaining to the implementation of the order dated 30/4/2022 of the learned GRF cutoff passed in CC number 246 of 2022. Keeping in view the present situation regarding testing and installation of the meter in the petitioner premises, in the event of failure of amicable settlement, the petitioner consumer and the respondent licenses shall appear before the learned GRF cutoff on 5/7/2025 along with all documents, and the learned GRF cutoff shall examine the correctness of the calculation to be made by the respondent licensee on revision of bills of the petitioner consumer for due compliance of its order dated 30/2022 passed in CC case number 246 of 2022, and submit a report to this commission in this matter. Here, my lord, by this order, it's amount to compounding the offense by the discom, my lord.
No, what happened thereafter? There was directed to revisit the calculation.
That order I challenge, my lord, because 146 is for
you are the consumer.
Yes, my lord.
Calculation has been done.
Calculation has been done.
Not yet done.
Then it is a you wait till
immature.
Not immature, my lord.
Then?
What I am doing, 146 is the provision for punishment for non-compliance of order and directions. Here, my lord, they have some. Before that, my lord,
we want to know that maybe
GRF has I came with
in view of the direction, the that calculation might have been made. Who knows that?
My lord,
because the specific direction was that
my submission is that
revisit the calculation.
They are a call for the GRF report that is in para 7. GRF report specifically stated that order has not been complied with.
As right now, there is an attempt made for settlement of the dispute.
My challenge is twofold. First of all,
technically you may have a case,
my lord,
but see,
that direction for settlement itself is without jurisdiction. That is my first.
Every day,
the mediation, the regime of mediation.
My lord, second, my lord, because there is no provision for compounding. Second aspect, my lord, while sending to me to the settlement, the court cannot direct such that the court cannot restrict myself to raise a claim to the benefit of others. Why
are you bringing so many theory into it? There is a calculation problem. The court says that let there be amicable solution.
Because in para 6,
recalculate. In between you come and bring so many things.
Para 6, OERC restrict me to claim the compensation as per the standard performance guarantee.
First of all, we want to know
Can it restrict while sending to settlement, while they can restrict to claim for the compensation.
Let us wait. What exactly has happened?
Petition has been filed by petitioner Ashok Ranjan Mahanti, challenging the order dated 10/6/2025, passed in case number 40 of 2024 by the
OERC.
OERC,
Respondent number 1.
Opposite party number 1, with a further direction to the commission to hear case number so and so afresh on merit, including the claim of compensation by the petitioner.
Exclude the possibility of any voucher.
Or in the alternative, the petitioner to be allowed to put forth the claim of compensation in the discussion for settlement. In the operative part of the implementing order, the London OERC has held as follows: quote, paragraph number 8 and 9 its entirety. When we posed a pertinent question to the London Council for the petitioner, that since there was a direction to the opposite party to revisit the calculation made on revision of bills
And exclude the possibility.
and explore the possibility of amicable settlement of the dispute, whether the same has been done or not.
Till date, I have not received.
No clear picture has been put forth by the Land Council for the petitioner. In that view of the matter, we think it proper to know, to ascertain the correct state of affairs. The notice to the opposite parties,
Mr. Mahana JP,
2 and 3. Opposite parties number 2 and 3, very much necessary. Mr. Maharana Land Council submits that he has instruction to appear for opposite parties number 2 and 3. Let a copy of the petition be served on Mr. Maharana in course of the day, and the matter be listed next week, that is on 22nd of December 2025. Mr. Maharana shall obtain necessary instruction in the matter, particularly any development made in terms of the order passed in the paragraph number 8 of the implement order. Yes, next.
It will be considered on that time.
Matter seems to be pending.
Yeah.
The matter as it seems to be pending.
Which one?
That OERC matter. I'll take instruction.
Get the instruction. Yes, item 6.
Item 6.
Yes, item 6, the notice is there. Sorry, dispense with certificate copy and another file, the OI number 273-266-301. But I have filed 2 petitions, 2 original applications, but here indicate that is 3. I have not filed 3 original applications. Your lordship directed to 3. You have to file 3 applications, but another is not available. That is in the large scale. That is legal size. That is not filed. The 2 has been filed.
One time to file.
If your lordship will feel that 2 is able, can your lordship can admit the matter on the basis of 2 original applications? I have not.
No, this there are 3 original applications.
Never.
And common order was passed.
Not common order.
Common order was passed. So
your lordship directed to file 3 original Xerox copy of
that's a judicial order. How can you?
Grades are different or same?
It is the same. All are same matter.
Same.
It is analogous. Analogous matter.
But date of appointment, seniority is different. Date of appointment and
Facts may be different.
The judgment is one. Judgment
maybe, but the facts may be different in all the way.
So we are just keeping it to next week. You do the needful. That IA you are to file.
Paper is there. Another copy is with me. That is what legal size.
Not to type it out your Union of India.
You and in the first hour you are making something.
Yes, I am objecting that EOA file, even if it is a common
maintainability.
maintainability.
The Land Council for the Union of India, Mr. Patra, seeks for an adjournment till next week. Place this matter on 22nd of December 2025. Mr. Nayak, Land Council, appearing for the opposite party, submits that he intends to file an application. Acha, okay. Intends to file an application regarding maintainability of the writ petition. On consensus of both the parties, list this matter after second week. Yes.
Item 7.
Next week, my lord, the reading of the tribunal, I have filed today, my lord. I am serving copy to the Mr. Mishra.
So don't file here. File because that will be scanned and come. File Mr. Swine and counsel appearing for the petitioner 6 time till next week to file the entire pleading before the Land Central Administrative Tribunal. Give serving copies on Mr. Mishra, Land Senior Panel Counsel for the Union of India, extent of this matter. Later, after a year. Upon file second week of 2020. फाइल करम दिन फाइल स्कैनिंग हबो से आसीबो तो यस नेक्स्ट
Item 8.
So as per the order of this honorable court, it is 1/12/25. I have filed an affidavit, and while filing an affidavit, I found that out of 3 persons who are junior to me, 2 persons have already retired from service, 1 person now is continuing service. Therefore, that person who is now continuing service was sought to be brought on record as opposite party because the order of tribunal is against me. He has not been affected by the order as on date. Therefore, I want to implead him as a party. Therefore, I have filed a petition to that effect, praying for consideration of the same. And I have also filed correction.
affidavit
That is on record.
Additional affidavit you have exchanged.
Yes, sir.
And have you served a copy on the?
Yes, my lord. I have filed.
Have you received the copy?
My lord, we have received the copy of the I.
Yeah, no, IN additional affidavit.
Additional affidavit.
Yeah, in terms of the, you see, Mr. Parhi.
Yes, that is additional affidavit also filed.
1/12/2025, we passed a specific order when a submission was made that they have not been implemented, have already demitted the office, and therefore they will not be affected by the order. And so that is how we asked him to file that affidavit, and he has filed it, and copy is stated to have been served on you.
Yes, we received the additional affidavit as well as that.
You can proceed here.
Yes, Mr.
Proceed your argument.
Yes, Mr.
In terms of the order dated 1/12/2025, the Land Council for the petitioner has filed an additional affidavit, and copy of the same has been served on the Land Council for Union of India. Which are the relevant paragraphs, Mr. Fine.
Yes, Lord.
Who paragraph upon liquidation the semane and for
My lord. Paragraph 10 of the affidavit.
Paragraph 10.
Yes, my lord.
I am now on the fag end of my service and I'm going to retire so and so. And in the event my prayer made in this so and so gate, the persons who being junior to me in the senior is so and so, race so and so shall not be prejudiced. As from among them, so and so have already achalekidan. Wherein in paragraph number 10, it has been stated that the petitioner is at the fag end of his service and is going to retire on 31/3/2026 on attaining the age of superannuation. And in the event his prayer made in the writ petition is allowed, the persons who are his junior in the seniority list of Group B shall not be prejudiced, as from among them A. Dharmarao and SMS Ahmad have already demitted the office. on 31/7/2010 and 31/7/2019 respectively. Yes, what is your prayer here?
In respect of other person, I have filed a petition seeking him to implead him as a OP number 7.
Our petition file koriche?
Yes, sir. I have file korichi.
Fine.
এটা হচ্ছে আই number 22274/20.
So এই যে লোকটার add হওয়া উচিত।
Sir, see now he is continuing only that person.
Then let it be Mr. Party, let it be allowed. This one person's name he wants to implead. Is likely.
Yes.
এই কেস রে ଗୋଟେ IA file କରିଛନ୍ତି IA number ହଉଛି 22274 of 2025 in which this is an application for amendment of the clause title for addition of one person, that is JV Apparao as a opposite party number 7. He's still in service, right? IA number so and so. This is an application for amendment of the clause title for addition of party. It is stated in the interim application that Mr. JV Apparao is now continuing in service and he could not be impleaded as a party to this petition inadvertently. And he was also not the party in the disposed of OA number 73 of 2020.
Yes.
All right. And it is stated that the said Apparao, the said JV Apparao is was the junior to the petitioner, and he has been placed above the petitioner in the seniority list of Group B officers.
Yes.
Group B officer under Annexure 8, and therefore he has a chance of getting affected, and therefore he is required to be added as opposite party number 7 in the writ petition.
Yes, my lord.
In consonance with the principle of natural justice, Land Council for the Union of India, who has received the copy of the interim application, has no objection to such prayer. Accordingly, prayer made in the interim application is allowed. JV Apparao is permitted to be impleaded as opposite party number 7. Have you filed the?
Yes, I have filed the consolidated.
The consolidated clause title has already been filed and copy has been served.
Yes, my lord.
Copy has been served on the Union of India. Yes, now you can proceed. Yes. With your arguments. What you are challenging?
My lord, next, the order on the Annexure 20 is now input before this Honorable Court.
Annexure 20. Okay, have you, like in other cases, we say that the entire pleading should come before us. Have you filed the original application?
Yes, I have already filed the previous order.
Please come to your original application, see your prayer. Annexure? Order achi?
Sir, input order achi.
Sector said, right. Sector said the order dated so and so. 23/9/2022 ta kono?
22, that order was passed. That order was passed by the opposite party number 1 pursuant to the direction of this Honorable Court, Honorable Tribunal, dated 25/22. ସେଥିରେ 3 similar persons cases were considered and they were allowed to seniority from the date of exercise of their option. 3 persons, this petition is one of them. Other 2 persons whose cases were allowed by the tribunal under Annexure 9 series, and against that orders, the Union of India came to High Court, and under Annexure 13 and 14, the 12 and 13 of this Honorable Court, those written petitions were dismissed. And pursuant to
your request was made to antedate the seniority.
Yes.
In the Group B was held to be devoid of merits.
Devoid of merit.
Right.
Yes.
And that was challenged before the Land Tribunal. And okay, then what was the order passed by in the operative part of the order? Okay. You come to
operative part is to paragraph 11, my lord.
11.
Paragraph
Continuing
11.
page 81.
Continue page 84.
84.
84 of the
81.
repeat.
81 from 81.
80.
Para
81.
9.
আচ্ছা,
Yes, my lord.
এটা পড়ুন পড়ুন।
Yes. The applicant
Never challenge the order.
yes, the applicant never challenged the order dated 11/5/09 passed by this honorable tribunal OA number 395/07 or the order dated 18/1/12 passed by the respondents in compliance to the order of this tribunal in OA number 426/09. The order dated 11/5/09 passed by this tribunal OA number 395/07 wherein his prayer for fixation of seniority was dismissed has attained finality. Below, the applicant, after a long gap, after the order of this honorable tribunal passed in court OA number 424 and 4225/09 was confirmed by the honorable High Court and implemented by the respondents, filed a representation dated 9/3/20 and approved this tribunal by filing OA number 228/22, which was disposed of as with direction to consider his representation. The respondents considered the same and disposed of his representation by the order dated 23/9/22, which is under challenge in this OA.
Okay, leave those, we come to that paragraph 11.
Yes, Miller. In further seen from annexure R/7 that the applicant in his option from her form had chosen for retention with a bottom seniority in the East Coast Railway. The tribunal, considering the said fact, had dismissed the OA number 395/07, wherein he had prayed for similar reliefs. The said order having attained finality, the matter is hid by principles of res judicata. That further, the applicant had also not challenged the order dated 18/1/12 passed by the respondents in compliance to the order of this honorable tribunal in OA number 426/09, wherein his prayer had been rejected by the respondents. The applicant cannot wake up at a further point of time and re-agitate the matter.
So what can be done?
Yes. Below, what has happened?
No, what has happened means the earlier orders stare at you, and on the basis of such orders, they have been placed above you.
Come to page 79. Come to page 79, para 6.
Yes, Miller.
Very detailed discussion. Para 6, if you see, the applicant in this way is claiming the seniority. The same prayer you made in 395 also.
Because this paragraph is very much important. I am just stating out the same. This applicant is claiming seniority basing on parity of the judgment passed by this tribunal in OA number 424 and 425/09, which was confirmed by the High Court, in which was implemented by the respondents. The applicant had earlier filed OA number 395/07, praying for fixation of seniority just below Sri C. Sahoo Hon'Ble in terms of a recommendation of respondent number 3 and treat him as employees of the East Coast Railway with effect from 1704 for all purposes. This way, this tribunal violates order 11/5/09 in OA number 392, 395/07 held as follows. Millard, paragraph 80, page 80, paragraph 7 is relevant. You will also may kindly take note of that. Because all the cases have been
reproduced part also read, para 7, reproduced.
Yes. The applicant
viewed the matter from all angle in your case. In 395, this was the order passed. Viewed the matter.
Yes. View the matter from any angle. The inevitable conclusion would be that there has been no wrong in the decision-making process for assigning the bottom seniority in the gradation list prepared by the respondents. Hence, both the ways stand dismissed by leaving the parties to bear their own cost.
That means that your seniority is
settled. What happened? Two original applications are filed before the tribunal. One is 392/07 and 395/07. 395/07 is the case of this petitioner. And the 392, the applicant of OA number 392, now he has been allowed.
Who was he? 392.
That is under annexure. That person is the The annexure 9. That person is Rajendra Naik.
Rajendra Naik.
Rajendra Naik.
Denied.
Millard, your lordship.
1 minute.
Yes, yes. Yes, yes. Millard, yes, yes. Now, after confirmation, he has been allowed the benefits. From the date of exercise of option. Yes. Yes, yes. That is that I am seeking parity in consideration. That aspect has not been considered by the Honorable Tribunal while passing the impugned order. And annexure.
Discussion representation that has been made that I gave the similarly situated like Rajendra. I think consider.
Your lordship may kindly see. Annexure 15 is the representation which was submitted by the petitioner pursuant to the order of Honorable High Court dismissing the original writ petitions of the Union of India. And pursuant to that, this petitioner submitted representation under Annexure 15 at page 63, 64. Millard, at page 64, para 5. Like me, the said G.S. Reddy and Rajendra Naik have filed OA number 424-425/09 before the Honorable Central Administrative Tribunal, Cuttack Bench, Cuttack, and the same were allowed by the order dated 8/12/10. Against the said decision, the Millard, so page 64, paragraph 64 of the writ petition. Paragraph number 5. Like me, the said G.S. Reddy, Sri Rajendra Naik and Rajendra Naik have filed OA number 424 and 425/09 before the Honorable Central Administrative Tribunal, Cuttack Bench, Cuttack, and the same were allowed by the order dated 8/12/10. Against the said decision, the exposed railway filed WB's number 2844/11 and 28446/11 before the Honorable High Court of Orissa, and the same were dismissed by the order dated 17/09. And finally, the Railway Board permitted implementation of our said order by letter dated 22/20. Millard, Rajendra case, that orders on annexure 9 series. The orders of tribunal. Yes, thereafter, yes, 42409. I am Ramchandra Sahu, 42409 and OA 42509. These two cases disposed by one common order under annexure 9 series at page 42 to 47.
11/5/2009.
Millard,
11/5/2009.
that order. Yes, that. Yes, Millard, I am just. Millard, my OA number is 426/26/09. 2009. ତାଙ୍କ ଦିଟା ହଉଛି in case of Rajendra Naik and yes, Millard.
Annexure 9 indicates that there are only original applications.
Yes, Millard.
That is Rajendra Naik
And put. Yes, Millard. No, thereafter, your lordship can see the next day at annexure 10. No, Millard, these two cases were disposed of by one common order, and my case was later on disposed of by the Honorable Tribunal. These two cases were allowed by the Tribunal, but when I refer these two cases judgment for the Tribunal in my case under annexure 10, Then, thereafter, after Annexure 9 order was passed, that Rajendra Naik, Milord, and yes, sir, Milord, Annexure or Annexure 7, the case of Rajendra Naik and the case of this petitioner, Milord, Milord, that order was not challenged. Why I have not challenged that order? Because in the gradational list, meanwhile, the gradational list was a publicity and the petitioner's position was downgraded therein. He made representation to the authority persons promoted group B have been placed above me. That representation was not considered. Thereafter, he moved the honorable tribunal. Tribunal said that his consideration, his representation is pending, that he be considered. And your lordship may kindly see on Annexure 7, two persons were before the tribunal. One was Rajendra Naik, another was this petitioner. Both the cases were dismissed. But in subsequent period, that Rajendra Naik and another Shankar Reddy filed two original applications before the tribunal. One was 424 by 09, another was 425 by 09. These two cases are allowed. At the same time, these petitioner filed OA 426 by 09. But these two cases were disposed of earlier. And those two orders were relied upon by the petitioner in his own case. But the honorable tribunal said your representation is pending before authority, and authority was directed to consider his representation, taking into account the order passed in OA number 424 and 425. Milord, that is very much clear at page 50, paragraph 6. Reference is made to that order also. Page 50, paragraph 6. Your Lordship, since the representation of the applicant on the annexure A by 13 is stated to be still pending for consideration, without expressing any opinion on the merit of the matter, this OA stands disposed of, with a direction to the respondents to consider and dispose of the pending representation at annexure A by 13 and communicate the result thereof to the applicant in a well-reasoned order within a period of 120 days from the date of receipt of copy of the order. They should decide the representation taking into consideration the order dated 30th August 2006, OA number 7, 8, 9, 25, 38 of 2006 of Jabalpur Bench of Tribunal, orders of 8th February 2008, and OA number 570 of 2005, and dated 2010 in OA number 424, 425 of 09, vis-a-vis the order 11509.
All right, all right. This writ petition has been filed by your consultation, consolidated yet তারপরে ফাইল করলে consolidated cost title বলি লেখা তারপরে this writ petition has been filed with a prayer for quashing the order dated 4/4/2025 of the Land Central Administrative Tribunal passed in OA number 173 of 2023. Inter alia, with a prayer for a direction to the opposite party to fix up the seniority of the petitioner in Group B in East West Railway with effect from 1/7/2004 with all consequential benefits, taking into consideration the order of the tribunal dated 18/12/2010 passed in OA number so in case of Rajendra Naik and G. Shankar Reddy under annexure 9, which have been confirmed by this court by order dated 17/5/2019, which are under annexure 12 and 13 respectively, within a stipulated time. Land counsel for the petitioner submitted that the petitioner is similarly situated like Rajendra Nayak. And also G. Shankar Reddy. And when both of them approached the Learned Tribunal in way number 425 of 2009 and way number 424 of 2009 and 425 of 2009. Both the cases were heard analogously and disposed of by the common order dated 8th of December 2010, and the opposite parties and were directed to treat them as the employees of East Coast Railway with effect from 31/7/2003 and assign them at the appropriate place in the seniority list. Stop. Though the petitioner also approached the Land Central Administrative Tribunal by filing way number 426 of 2009, his case was disposed of separately.
Separately.
By order dated,
Dated 18/8/11 on the Annex 10.
18/8/2011, and specific order was passed since taking into account that the representation of the petitioner was pending for consideration. The Learned Tribunal disposed of the OA without expressing any opinion on the merits, directed the opposite parties to consider and dispose of the pending representation and communicate the result thereof to the petitioner in a well-reasoned order, and such representation was directed to be considered taking into account so and so page number 15. The Land Council for the petitioner submitted that tapare kon hala hai you reject
Tapare se they passed an order on Annex 11. Pursuant to that order, they passed an order on Annex 11 that is dated 18/1/2012 of page 51 to 53. They said that we have gone to High Court against the order passed in way number 424. Then your case depends upon the outcome of that case. So this petition waited for the outcome of that case. Those cases were disposed of in the year 2019 by dismissed Union of India petition. Pursuant to that, this petitioner made a representation to the authority saying that the order of the tribunal passed in case number OA number 424 and 425 has been.
Say representation
Say representation under annexure, sir, in annexure 15.
16.
15. तापर आ गोटे रिप्लेसमेंट 16 ଦେଇଛି ଦେଖନ୍ତି 15 ଟା होची
ठीक अछि जहां भी सर कोन हला अल्टीमेटली
ये दिरा रिप्लेसमेंट देले कंसीडर न होला तापर ही केम टू ऑनरेबल ट्राइब्यूनल इन ओए नंबर 228/22 under annexure 18 सेथरे डायरेक्शन होला जे हिज रिप्रेजेंटेशन इज पेंडिंग दैट बी कंसीडर्ड नेसेसरी ऑर्डर बी पास्ड annexure माने 18 रे जो ऑर्डर पास होला
then subsequent representations were filed and the petitioner, since those were not disposed of, the petitioner approached the London Central Administrative Tribunal in way number 28 of 2022, which was disposed of on 25/2022, directing the disposal of the representation of the petitioner in accordance with law by passing a speaking and reasoned order. And ultimately, the order dated 21/9/2022 was passed by the authority concerned, and wherein it is stated that the request made by the petitioner to antedate his seniority in Group B is devoid of merit for consideration, particularly in view of the order of the Central Administrative Tribunal Cuttack Bench order dated 11/5/2009 and 18/8/2011. It is the submission of the Land Council for the petitioner that when there is no dispute that the petitioner is similarly situated like the
Rajendra Naik and G. Shankar Reddy.
Rajendra Naik and so and so. And the who have got the necessary relief, and when in the original application on 426 of 2000, 426 of 2009, filed by the petitioner, specific direction was issued to consider the petitioner's case, keeping in view the orders passed by the Land Tribunal in the case of so and so, है ना? ये जो राजेंद्र नायक और ये, है ना? This order which has been passed rejecting the claim of the petitioner on 21/9/2022 is not sustainable in the eye of law, and the Land Tribunal has also mechanically held that the petitioner is not entitled to get the relief. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission, since the Union of India, the Land Council so and so has already entered appearance for all the opposite parties. Extra copies of the writ petition be sought, and matter be placed after 4 weeks, for example.
But why the notice should go to the private opposite party?
Private opposite party, so and so, opposite party number 1 and 6, for example. So far as opposite party number 7 is concerned, requisites for issuance of notice be filed by 19th of December 2025. Hello? Matter place कर देंगे तो आपने counter affidavit. Yes. All right. It all right. आपने कौन बोलना? ईशान. Just come.
Item 9.
May I please? In compliance to my lord's order, I have filed copy of order passed in case of Kesav Chandra Mahapatra and others, my lord, along with memo at flag B. Here, my lord.
Just a minute. You come to the page number 4 of that last order which you have passed in on 3/12/2025.
Man,
it is the contention of. Did you get it, sir? Page number 4.
my
It is the contention of.
my lord, it is the contention of running council for petition that WPC number 8083 of 2018
Yes.
was in fact filed by the Union of India challenging the order passed in ONM, which was filed by Kesav Chandra Mahapatra and seeking similar relief like the petition, which was allowed, and the writ petition was disposed of for non-prosecution as per order dated 14/7/2020. When counsel for the petition seeks some time to produce the order passed in Kesav Chandra Mahapatra by the non-tribunal. However, as per previous order dated 26/11/2025, he has filed a writ petition of his manner. Mr. Padil on a DSJ also seeks some time to obtain instruction as to whether any interim application has been filed in WPC number 8083 of 2018 to recall order and to restore the petition. When counsel for the petition submits in case of Kesav Chandra Mahapatra, the order passed by Learned Tribunal has already been implemented.
So that is why we wanted to know that what order has been in fact passed
File.
with the
I have filed.
Union of India.
Yes, my lord. We seek
dismissal.
instruction, my lord. Last occasion also took time, my lord. We allowed time to take instruction.
So that
I
has
didn't
been
receive.
implemented, Mr. The submission was that was implemented. So what is the question of now?
Challenging.
Challenging now.
I seek instruction in that regard to the department.
Yes.
But were not received. Last chance may be given. Authorized lords may pass necessary order.
May I pray, my lord? Your lordship kindly give a glance my memo at flag B. The Learned Tribunal dispose of way filed by Kesav Chandra Mahapatra, that is OI number 7.
Copy also.
Agya.
Yes. It is the Kesav Chandra Mahapatra order.
Agya. Page 2, my lord. Para number 2.
Page number 2, para number
2, my lord.
O is allowed. And so is quashed. Respondents are directed to grant fast financial upgradation to the applicant with effect from 30/3/2000, treating his induction as a trainee as regular service.
My lord, para 2, line number 2, my lord. Learned Tribunal referred 2 orders passed in previous cases, my lord, to allow the prayer in 764. Your lordship kindly give a glance page
OI number 760 and 763.
Agya. Page 4, my lord. Page 4 is the order passed in OI number 763 of 2014, my lord. In case of Ashok Barik.
Okay.
That order carried by the present opposite parties before this order court, my lord. Your lordship kindly give a glance page 17, my lord. The writ petition filed by the present writ petitioners, opposite parties. This order court by the order dated 3rd January 2019 was pleased to dismiss the writ petition, my lord. Then, my lord, matter carried to Honorable Apex Court. Though earlier a batch of cases disposed of by division bench, finally the matter referred to full bench, my lord. Full bench by the order dated by 22nd October 2019 was pleased to dismiss all the special petitions filed by the present parties, my lord.
Yes, bench decision. Okay. We find no grounds not. How can achieve
That's why, my lord, the writ petition they
Yeah,
remain
it's-
absent in the.
It's true for first occasion on 3/12/2025, an order was passed, my lord, directed to obtain instruction. So another one chance be given, thereafter let's me dispose because you have to take. It's the first time.
Mr. Hari.
Yes. Again. Yes. Again.
पुणा वर्ष से relief टा पांच उतारो.
Again.
person पाइछन दियो.
Or let's me give you 20 seconds also. 20 seconds.
Friday as well. ତାହେଲେ Friday
ହଁ ଫ୍ରାଇଡେ ରଖନ୍ତୁ କିଛି ନାହିଁ
the Mr. P.K. Pari and the Solicitor General 6th adjournment till Friday to obtain instruction as per the order dated 3/12/2025. Stop. Some documents have already been filed by the London Council for the petitioner, which are at Flag D. This matter on 19th of December 2025. The London Solicitor General shall apprise this court regarding the order which has been passed on in the case regarding implementation of the order passed by the London Tribunal in the case of Chandra Mahaprabhu. Yes, next.
Item 10.
Alright, item 10, it says surfacing matter minutes. My account has been NPA on 1st September 2025. Then after my lord, I have I have received 13 to notice on 22 September 2025. Then my lords, we have filed one representation for the one-time settlement, my lords. And then my lord,
that is 8/10/25.
8/10 to 2025.
What happened to your representative?
And no action has been taken on this.
You have not received any communication.
No, my lords. And it is a
and not no notice on the 13/4.
No, 13/4 has not been. And the entire case stands on the 13(3) subsection 1.
ମାନେ ଆମେ ଖାଲି ପଚାରୁଛୁ 8-10 ମାନେ 2 ମାସ ଉପରେ ହେଇଗଲାଣି ନା
ଆଜ୍ଞା
ଆପଣ କହୁଛନ୍ତି have you taken a ground that after this annexure 6 you have not got no response where have you stated? Let us see annexure 6 ପରେ
not said
But
anything.
para 6 minutes. Para 6.
Para 6 ରେ କିଛି କହିନାହାନ୍ତି.
Para 6 ରେ କଣ?
Para 6 ରେ
rather you have stated that they are now trying to sell the mortgage property through auction, taking possession under section 13.
And they're planning actually.
After planning ଆପଣ କଣଟା ଆପଣ ପଚାରନ୍ତୁ ଆପଣ 13 to notice ପାଇଲେ ତାପରେ ଆପଣଙ୍କର 13th year representation ଦେଲେ representation ଦେଲା ପରେ ଆପଣ ବ୍ୟାଙ୍କ ତରଫରୁ କୌଣସି intimation ପାଇନାହାନ୍ତି ଏ averment ଆପଣଙ୍କର କାହିଁ?
Have you understood the scheme of law? What is the scheme of law?
But after representation, the bank has to communicate with us.
Communicate a region order.
Region order.
That has not been done according to you. Where have you made the averment? That is only your case. Beyond that, there is no case. Otherwise, you have to go to the alternate remedy. So that is the only case.
If you are sure that your client has not got any response, please bring add to that paragraph by way of an amendment so that we can take up this matter.
We can ask the bank
other side that why have you not responded? Because the period has been specified therein and how they are to deal with that is also specified. Are you having this book with you?
My lord.
Please come to.
Well, young man, you see the scheme of law. Accordingly, you have to draft petition.
And the thing is that the
one word, one sentence is missing. Therefore, you have to
come to 13(3)(a).
13. If on receipt the notice of subsection 2, the borrower make any representation or raise any
you are making any representation
or raise any objection, the secure creditor shall consider such representation or objection, and if the secure creditor comes to the conclusion that such representation or objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such representation or objection.
So that 15 दिन ଭିତରେ ଆପଣଙ୍କୁ ତାଙ୍କର ଦାୟିତ୍ୱ ହଉଛି ଜଣେଇବା କଥା either reject କରନ୍ତୁ but not acceptable whatever it may be. ସେଥିପାଇଁ ଆପଣ କହୁଛନ୍ତି ଯେ ଆପଣ କୌଣସି ଏପର୍ଯ୍ୟନ୍ତ ପାଇନାହାନ୍ତି but ଖାଲି ମୌଖିକ କହୁଛନ୍ତି there is no averment, no pleading. So you include that pleading, will entertain. ହେଲା? The writ petition has been filed by the petitioner Bharat Swain with a prayer such and such. The Land Council for the petitioner submitted that after receiving the notice dated 22/9/2025 under section 13(2) of the Surface Area Act, the petitioner submitted his representation on dated 8/10/2025 under Annexure 6. It is the further case if the Land Council for the petitioner submits that no response has been received from the opposite party, finance bank, and averment has been taken in the writ petition that the opposite party are now trying to sell the mortgage property through auction, taking position under section 13(4) of the Surface Area Act 2002.
List of date, list of date, 22/9/2005 notice under section 13(4) Surface Area Act was issued. List of date.
Mr. Counsel,
Yes.
you have mentioned that 13(4) notice.
See the list of dates, date chart. What have you written?
Is it an incorrect thing or what?
22/9/2025. Notice under section 13(4) of Surface Area Act 2020 was issued.
Is it 13(4) or 13(2)?
My lord, it is 13(2) minutes.
Why have you mentioned 13(4)?
Then you are out.
Wrongly, my lord. It was drafted by someone else. That is the main problem.
Yes,
Because you have not read the provision before drafting.
When we pointed out to the London Council for the petitioner that in the date chart and event, it has been mentioned that on 22/9/2025, notice under section 13(4) of the Surface Area 2022 was issued. The London Council submits that inadvertently, in place of 13(2), it has been mentioned as 13(4) stop. The submission of the Land Council for the petitioner that no response has been received from the bank in terms of the provision under section 13(3)(a) of the Surface Area Act is not pleaded in the writ petition. Land Council for the petitioner seeks for an adjournment to file an interim application for amendment of the writ petition, put up this matter on
Short date again.
କେବେ କହୁନାହାନ୍ତି?
22 ତାରିଖ
20 here on 24th of December 2025, if an interim application for amendment is filed, the same shall be placed on record. Yes.
Item 11.
This writ petition has been filed challenging the order of OERC Ombudsman, wherein
In this matter, I have instruction to appear, and today I am filing my Vakalatnama in the registry.
Have you received the copy of
I have received a copy of the
taken instruction?
This instruction is yet to come. Let's see, if your lordship will
Tell us the date and
let's say in this week, if your lordship, 19th or 18th.
19th.
Yes, that's what I was subject to your lordship's consideration. Railway department is against the electricity department. I have requested the department to explore the possibility if it can be interdepartmental, it can be settled. So your lordship.
Yes, there is no objection. Yes.
We'll keep it after vacation.
Yes, only to that effect instruction.
Can be sorted out. Better, the two departments will sit and have an.
Yes. I'll advise you. Yes.
So,
I'll-
Mr. Pari, we are placing it after this Xmas holidays.
Yes.
And the appraisers.
I'll appraise the.
Yes. Yes.
I was going through the brief and I could point out it's a commercial dispute.
It can be. It can be. No issue.
Record the Mr. Mahapatra, Mr. Maharana, Mr. Maharana and counsel appearing for the opposite party. Number?
I'm appearing
All
for all opposite parties.
Acha.
1, 2, 3.
TPCODL appearing for TPCODL submits that he has received the copy of the writ petition and the matter is such that if it can be resolved by way of discussion between the two departments, that is railways and the TPCODL authority, and the matter may be placed after ensuing Xmas holidays, so that you will apprise this court about the development, if any, made in the meantime. All right. Put up this matter second week now.
Second week, yes. Mr. Jagyamal Manti appearing with you. Let's meet.
ନା ଲେଖିଦିଅନ୍ତୁ କାହାକୁ ଗୋଟେ ପଠେଇ ଦିଅନ୍ତୁ ସ୍ଲିପ୍ ଦେଇଛନ୍ତି.
He is in court. He will say. Yes.
ଆଚ୍ଛା.
Item 12.
May I please your lordship?
Yes.
Pardon, my lord, I am on PC. My lord, in this case, we have filed some amendment to the writ application. May kindly it be
that interim application has been
may
filed.
come in Thursday.
Learned Council, can you have the number of those interim applications?
IA number, my lord, IA number 22484.
22484 of 2025. It has been filed for amendment of the writ petition.
Yes, my lord.
Today you have filed.
Yes, my lord.
Okay. What
Yes,
is
my
your
lord.
good name, Mr. CS?
Yes, Padhi.
Mr. CS Padhi, Land Council for the petitioner, submits that today an interim application has been filed, which has been registered as IA number 484 of 2025 for amendment of the writ petition, and the same be placed on record. Place this matter on Friday, that is on 19th of December 2025 with IA number so and so. We are listing it on 19th December. Okay.
Obliged.
Item 13.
Pardon, my lord, I am on BC appearing on behalf of Mr. Samarendra Beura for item 13 and item 14. My lord, in item number 13, the compliance affidavit has been filed and the reply affidavit has also been filed on 13 December, but the same has not been reflected on the noting, my lord. But in item number 14, the compliance affidavit has not been.
13 the copy objection for the reply objection.
No, the compliance affidavit has been filed by you. That means that one Boishakhi Lenka with the Tahsildar Damopada. Yes, filed. You have filed one objection to this compliance affidavit.
In item number 13, ma'am.
हाँ सही 13 ही कहूँ.
Yes, ma'am.
केबे फाइल कले objection?
13 December 2020.
Have you received a copy?
No, 13 December.
13 माने शनिवार दिन शनिवार सेकंड सैटरडे थिला फाइल कले. अच्छा हो. अच्छा कहूँ ता नाटा देखले कौन लेकर. What is your good name?
Abhay Kumar Swami.
Abhay Swami. Abhay Kumar Swami and counsel appearing for the petitioner submits that objection has been filed to the compliance affidavit filed by the Tahsildar Damopada, opposite party number 3, on 13th of December 2020. The Land Council for the state submits that copy of the objection has not been received. Stop. let the registry place the objection on record and let a copy of the objection be served on the land council for the opposite parties of this matter after we get for them winter holidays for them. Yes, next.
Item 15.
14
for the respondent. For the respondent.
The theory wala na 14 uta achi.
Item 14.
Chowdhury also I am appealing on behalf of Mr. Samarendra Beura. The Chowdhury compliance affidavit has not been filed.
Today we have received time to file.
Acha, the land council for the opposite party submits that he has received the necessary instruction and during course of the day the compliance affidavit will be by day after tomorrow. The compliance affidavit will be filed and copy of such compliance affidavit will be served on the learning council for the petitioner. Please, this matter should be Nijam Shruti Kaur.
Obliged, man.
Item 15.
For the respondent.
And for the appellants, Your Lordship.
The matter has been extensively argued on the last
The
occasion.
arguing
Kindly
counsel is on
well
its way to
considered
Supreme
detailed order
Court,
has
so I
been
kindly
passed
ask for a passover.
Passover.
Extensively, the matter has been argued. And it's a
The
concluded.
mention was
The
made,
recent judgment has been rendered.
Mr. Nataraj, the mention was made that some interim application has been filed for some, I do not know, for modification of the
SLP
judgment.
has been, yes, SLP, that order has been confirmed.
SLP has been dismissed thereafter. How a IA is
How they are making this application?
Let us hear this. What is this IA actually? Land council?
Can I, sorry, my lords, I was not there. Sorry.
Yeah.
My lords, this application which I have filed is, my lords, your lordships, there were certain terms of settlement which were placed before my lords, which was a term of settlement on 4/9/2025. My learned seniors on the other side had also intervened, and finally, my lords, this matter was settled, which finds mention in this detailed judgment of my lords. The said settlement, my lords, had 4 terms, my lords. Would your lordships kindly come to those 4 terms, my lords, which were there, which was part of my lord's judgment at page 126 of this IA paper book.
In your IA, you filed it?
Yes, my lords. We have filed the whole judgment, my lords.
Okay. Then
kindly come to the judgment which is filed in the IA only, rather than getting into the
126. You say
126, my lords. I will restrict it, my lords. I am not reopening the matter or anything of that.
Re-arguing the matter again after the dismissal of SLP in Supreme Court.
So, my lords, I withdrew the SLP, my lords. I withdrew the SLP. But I withdrew the SLP.
Matter, where is this?
Let me place my learned seniors are certainly know the complete wherewithal of the matter. Let me just place my matter for whatever little work I can project, my lords. Yes. Kindly see page 126 of the IA paper book, my lords.
126 of the IA. Yes, sir.
My lords, kindly come to. There were certain terms of settlement and all which were there, but that got basically coined into this page 126. Has my lords got 126?
Yes, please.
Kindly see, my lords. This is what the appellants humbly state and submit that following demands as raised by the appellants are required to be brought to the knowledge of this honorable court. Expeditious and timely completion of the work at the resettlement site as per the approved plan, preferably within a period of 6 months. My lord's order was of 24/9/2025. And my lords, there were 4 points. Let me just read out those 4 points quickly, my lords. The second is to provide company quarters as transit accommodation for 27 numbers of appellants within a period of 1 month, and subsequent to which the said appellant shall vacate their lands in the acquired area within a period of 1 month hence. Number 2. Number 3 is expeditious disbursement of house building assistance, rupees 3,39,000 to the appellants as provided in the 9th biennial revision of rehabilitation grants in monetary terms with a resolution dated so and so of the Revenue and Disaster Management Department of Odisha. Serial number 4, my lords. Incentive for early and expeditious displacement of PDFs at 10 lakhs as per the decision taken in 12th RPDSC meeting dated so and so. My lords, let me state at the outset, in all fairness, only serial number 1 and 2. That's what my lord says, because the respondents in para 21, these were the 4 points. Kindly see para 21. The respondent said that they acknowledge the demands under 1 and 2, my lords. Para 21, I'll read that part also out. The respondents filed an affidavit on the self-same date, my lords, wherein it is stated that all the land losers have got the land acquisition compensation in terms of the applicable law. Besides, in terms of the policy, the eligible persons have been allotted sites. It is further stated that the resettlement work is in advanced stage. In response to the precise demands raised in the affidavit filed by the appellants, the MCL company acknowledged the demands as mentioned in 10A, small Roman 1 and small Roman 2, my lords. It is stated that an earnest attempt would be made to meet the demand of the land losers. So far as paragraph 10A2 is concerned, it is stated that out of all the persons in terms of the list enclosed in the affidavit dated 4/9/25, only 25 are stated to be not granted the alternative accommodation, who would be provided with alternative accommodation within a period of 1 month subject to their eligibility. The appellants would be given all the benefits in accordance with law subject to their eligibility in terms of the law as applicable. It is stated in the affidavit dated 4/9 that the writ appeal be disposed by vacating the interim order to enable the respondents to proceed with hassle-free manning operations in the site in question. So, my lords, today the real problem is, my lords, what has happened is that insofar as serial number 1 is concerned, if my lords may go back to page 126, serial number 1 is concerned, my lords, MCL had called for tenders. Those tenders are
when the Supreme Court was not inclined to hear all these things, there is no point in filing one more application.
That is why I withdrew the petition to come before.
This order was challenged before the Honorable Supreme Court.
Yes. It is dismissed already. They have court wanted to dismiss on the first day. On second day,
Mr. Panigrahi, please come to your prayer in the application.
Yes.
Please come to your prayer in the application.
Yes.
The first prayer, insofar as the first prayer is concerned, 1 and 2, no clarification is required because this is Roman 3 and Roman 4 are for the order, settlement order, isn't it?
Yes, my lord.
And what about 3, 4, and 5? These are the addition. What clarification? It is addition.
No, my lords. These are not additions. These are as per the
scope of the
339, my lords, had actually become 420.
339 is the settlement term 3.
Correct.
And 10 lakhs is settlement number 4. No clarification is required. There is a specific
what I'm trying to say, insofar as 1 and 2 are concerned, my lords, even 1, the tender which they had called for, that tender has been today revoked. So we are now 3 months basically, my lords, and today no resettlement.
Why are you 6 months time has been granted to them?
My lords,
that
today
period is yet to be passed.
I am cognizant of that, my lords. I am cognizant. But the problem today
is modify and clarify after the dismissal by the Supreme Court of the SLP.
Mr. Panigrahi, the time has not elapsed.
Clarify the order.
My lords,
time
all that I am saying, my lords, please appreciate, my lords, your lordships had intervened this because, my lords, this is a human problem, my lords.
This is
not a challenge. We are also understanding, my lords. We are.
Do you mean to say that we will fix that by this date the tender will be finalized?
No, I am not.
Will be done. So what do you want now?
All that today we want is, my lords, the resettlement. The resettlement would be basically a house. And my lord, even around
vacate the premises and create trouble for the problem.
My lords, if I vacate, my lords, I go to a place where, my lords, I have to stay there. Today, my lord, how do I stay there?
Create nuisance and keep this application pending. But there is no scope after the dismissal by the.
We are doing one thing. Since we have granted 6 months time, we are keeping your interim application for consideration after 6 months. Let us see that you are aggrieved because they have not taken or some steps have been taken. You say that has been revoked. That is why your apprehension is that perhaps that cannot be, number 1 may not be possible to be complied with that within that which assurance was given. But since the period is
May I submit this is a premature application on sincerely on apprehension. We will keep it after 6 months. Let us see if they are complying or not. Because this order, the judgment is now confirmed by the Supreme Court. They have to comply within 6 months.
Let me say, my lords, I had
1 minute. Let me submit, my lord. This pendency of this IA will also, my lord, would be taken as a, my lord, they want to create some disturbance that we are still in High Court. So let them come if at all, my lord, your lordship have already passed certain directions. And that is on consent of the parties. They went to Honorable Apex Court, it was dismissed.
Okay, we will follow it.
They may come after 5 years.
My lords, I withdrew my SLP to come to this court. This was an order of consent and this court could only modify it, my lords.
Straightway, there is no cause of action now. Keeping this application pending also, my lord, they want to create some kind of nuisance.
So, my lords, what my lords, MCL is a huge.
We will give liberty to revive application if necessary.
That's correct.
My lords, can I just say, my lords, if they at least give us serial number,
they want to create this problem, Miller. That is the whole object. After the dismissal, it's a completely ill-advised application.
Can I just, my lord, say
to modify the judgment after the dismissal by the Supreme Court?
Please.
Can I, my lord, as a last prayer, can I just say, my lord?
For modification, what is the prayer? Modification or clarification of the judgment dated so and so, to the extent so and so. It is brought to the notice of the court by the Land Council for the Mahanadi Coalfield that challenging the judgment and order dated so and so, the petitioners approach the Honorable Supreme Court in so and so, and the same was withdrawn, dismissed as withdrawn as per the order dated 5/12/2025. Copy of the order is filed, which is taken on record. The main apprehension of Mr. Panigrahi is that even though in the impugned judgment, even though in that judgment timeline has been fixed, that page number
126, my lord.
126. Timeline is fixed. Expeditious and timely completion of the work as per the approved, preferably within a period of 6 months. But a tender in that respect was floated, which has been withdrawn in the meantime. The Learned Advocate General, so also Mr. Natarajan, submits that since the this interim application is a premature one and the time as stipulated therein has not expired. So, in view of such submission, they have reassured that necessary steps will be taken to comply the order in its true letter and spirit. And in view of such submission, we give liberty to the petitioner to file any application if the order is not complied with to its letter within the stipulated time.
My lords, can I ask, lords, I was sorry, I didn't interfere. My lords was dictating the order. My lords, I was making a request, which on instructions I was making, my lords. I want to just forget as of now, my lords. What I was saying is, if at all they give me that house building allowance also, my lords, as per my entitlement, my lords, that's they are saying that house build, then I can start constructing my house. There are others who have started.
All these arguments are being made in Supreme Court.
My lords have said 60 people. So, my lords, I can't be deprived of that 3,09,000.
No, Mr. Panigre, have they denied? Mr. Panigre, have they denied?
But my lords, if I get it, because 3 and 4, my lords, they have not acceded to, they have not acknowledged. That's what this judgment says.
The whole
judgment penalty.
It can't be true. My lord, just please bear with me, my lords. All that I'm saying is, my lords, 3 and 4.
Have you stated anywhere that they have denied it?
have you,
My lords, it's
have
not
you,
acknowledged.
have you,
Your lordships have said in your own judgment. Kindly see, my lords. That's
No,
what
that's
I
right. But have they denied it?
Not
My
obstructing
lords,
the
if
administration.
I am now making a request.
Staging dharna, all those things, my lord. Again, they are
My lords,
setting.
can I just? I know, my lords, what my lords. I am not much aware, as my lords on the other side, my learned seniors are aware. All that I am saying is, my lords, if that 3,39,000, which is a house building allowance, if that is
Whatever
given,
is
my
true,
lords, they can start building their houses, my lords, today. Please appreciate it.
Judgment has attained finality. There is no question of looking anything
My lords,
further.
attained
That's all.
finality, but my lords, I
See,
came.
but see, the problem is 6 month time is granted. It is premature state. We can only, we can only, we can only persuade. You can only persuade them that at least they should release
My lords,
that house.
it's cold winters, my lords.
All those arguments, my lord, were advanced before the appeals court. It was outrightly rejected. Now
My
he
lords,
wants
I
to
came
revisit
to
it
this
again.
court saying that I will
Same
give an
argument.
application, my
No,
lords.
no,
I can't be.
that's right, Mr. Acharya.
Abuse.
See, they are entitled to these house building assistance. What he says is 6 month time is granted. Why don't you give them?
Whatever
Give
is
them.
given, it would be given, and many things are given more than what they deserve. Now their intention is to create.
No, this is see, house building assistance is Roman 3.
They have taken.
Is Roman 3 entitlement.
So whatever you wanted to give, that has been given and approved by the Supreme Court after hearing both
Yes.
sides.
No, there is no
Even I was
approval, my
there,
lord,
gave
that
it.
it was a
No question of
consensual
reopening
order.
it.
Your lordship,
Consensual order, that's why I came to this
judgment.
court, my lords.
That your lordship have given kind consideration to
Yes,
all
my lord.
aspects. It's a well-reasoned order. Supreme Court did not interfere. Now he wants
Supreme
to
Court's
bring the
interference
points before your lordship.
My lord, Supreme Court's interference today is not the point today is, my lord. I am agreeing to the fact that it's a consensual order and it is my lords who can today modify this order. That's why
Getting
I
your
asked
lordship judgment tested in Supreme Court, he wants to, my lord,
no, there is no bar for me to come to this court to seek
No, there is
modification.
bar, absolutely bar. No,
No, I am not barred. As per rules, I can certainly say. I am requesting, my lord, please.
After the principle of merger, Mr. Panigrahi, you must be knowing as a Supreme Court practitioner, no IA in a disposed of petition is maintainable. That must you should know.
This is a consensual order for modification. I can
The
certainly
order is
come
not
to this court.
implemented. This is not the proceeding. Some other proceeding is
Mr.
contemplated
Panigrahi,
under law.
the question of modification of a judgment which has already reached finality by when
Correct, my lord, it's a misconceived
and
petition.
withdraw it. Where the question of modification arises.
I
will not go against that order of dismissal.
Another problem is, Mr. Panigrahi, another problem is this is basically a consent order.
Yes,
Once there is consent order, where is the question of modification?
Look at the language.
Your lordships
Modify the order after the.
I think Mr. Panigrahi,
Finally, it has come for a modification of the order.
Advocate General Sahab, I think we'll see after 6 months whatever the rights.
We will wait. See, if they don't comply with all the conditions, you have a right to approach. We have reserved that right. Reserve that right.
All right. Thank you very much for all
of
this.
Let it be, Milord, dismissed, Milord.
They are giving you liberty and I am disposing of the eye. Okay, next.
Flash, my lords, for patient hearing.
Item 16.
You know, like for the previous order, I have already signed a copy of the application. If you have with the application for condemnation of the we should be given a copy. I already any objection or unclear?
Well, review is not maintained.
No. Delay condonation କଥା
ଲସି କଣ୍ଡନ ଦେଲେ
ଆଜି ଆସିଛି ସେଇଥିପାଇଁ ତାପରେ ଆସିବ ଇଏ ପାଇଁ ସେଠି କହିବା କଥା ଦେଖନ୍ତୁ IA number 413 of 2025 this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 81 days in filing the review petition. लिखी दो आपन serious objection नहीं Mr. Rauthrel and counsel for the opposite party though raised formal objection but submitted that he has no serious objection in condonation of delay considering the submission and the grounds taken in the interim application.
May I prevail? Condone the delay.
Subject to payment because review petitioner is the BSNL company.
Payment to you.
No, back.
Yes, Mr. Barik, he is a good suggestion here.
That can be go in favor of.
No, sure, all right. Upon kete debe kondu 20,000 above kondu. Padu karsa. Upon bar member
Less amount is insert to you.
हाँ bar member पाइबे अपन को 20,000 ऊपर हो जाए कौन धरे नहीं
20,000
नहीं
I know.
that will foresee about
Your lordship.
someone crusher so they 20 subject to deposit of rupees 20 no serious objection but submitted that some cost should be imposed and it should be paid to the High Court Advocate Welfare Fund in view of some so on so 20,000 and then review petition be placed for admission. Yes.
Well, may I please let it come on 19? Because he is pressing hard for
All right,
implement of the order.
19th of
Contempt
December
application.
2025, that receipt to be produced from that. All right.
Mobilize one.
Item 17.
I'm appealing for the petition. In this case, I have taken a electricity connection from the opposite party for my cursor unit. Thereafter, another cursor unit of OP number 4 has been installed.
Who has filed the interim application for vacation?
My lord, I have filed, my lord. I am for the occupant 7, my lord. Here, my lord, in the year 2023, my lord, I made an application for my lord.
No, have you given that copy to the?
Yes, I have given copy.
Counter affidavit by the
I have filed my counter affidavit.
No, what we say that whether we'll hear this interim application or decide the matter finally. Because if you have filed the counter affidavit, etc., then why should we again vacate or anything decide? We can decide the matter on merit itself.
Yes, my lord.
So the pleadings are complete. What we want
No,
to
my lord, because department has no, electricity department has not filed the counter affidavit.
Mr. Maharana was appearing for the my lord, department. My lord, he was here. My lord.
Where is he?
My lord, he was saying that.
So what do we say that why instead of going to that vacation of stay, if we can adjudicate the matter on its merit and once you file the pleadings are complete, so that would save the purpose. This time would be saved in that way. We can fix it to after this ensuing Xmas holidays and particularly
fact,
in the meantime you file your counter affidavit.
I have filed my counter affidavit.
No, about the Maharana.
Yes. Mr. Maharana was here, my lord. He was
Yes.
Mr. Maharana, an application has been filed for vacation of that interim order, but if you file the counter affidavit, we can finally adjudicate the matter, and we can place it after Xmas holidays, so that okay.
In fact, my lord.
Yeah, we half page, then don't.
And in fact, my lord, what happened, my lord? Under Annexure 1, the impugned order was there, my lord. There, my lord, he had approved this unopposed earlier and this unopposed.
Mr. Maharana is appearing for which opposite parties?
For OP 1 to 4.
1 to 4. And you are appearing for OP number?
7, my lord.
7. Asha, 5, 6, they are not necessary. Let one. IE number 2, an interim application has been filed.
Subject to lordship.
IE number so for vacation of the interim order. Dated interim order dated kebe karo?
2/5/2025.
However, it appears that counter affidavit has been filed by the opposite party number 7. Mr. Maharana, learned counsel, appearing for the opposite parties number 1 to 4, seek some time to file the counter affidavit.
I'll file it today, Mother.
Acha, submits that he will file the counter affidavit in course of the day. Stop. Let copy of the counter affidavit be served on the learned counsel for the petitioner as well as learned counsel for the opposite party number 7. Put up this matter after
main matter will dispose
with the rejoinder file query parandi
why dispose of
ଆଜି dispose of ହେଇଯିବ subject because under annexure 1 my lord
କେସ୍ ହଉଛି ପିଟିସନର
ନାଇଁ ନାଇଁ what
ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର ଦିଆଯାଇଛି ତାଙ୍କ ଫେଭରରେ
no, what we are discussing
କାଉଣ୍ଟର ପାଇନାହାନ୍ତି ଆପଣଙ୍କୁ ଡିସ୍ପୋଜାଲ କରିଦବ
ନାଇଁ
କି
ନାଇଁ
ଆଶ୍ଚର୍ଯ୍ୟ କଥା
it will be remanded to the
ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍
because my lord
all the party agree, then we will remand.
yes,
but he has not gone
I have the
through
petition. I have
Oh, you are-
my signature.
that is my submission miss I am for
What has happened? The original order was challenged in appeal before the ombudsman. Ombudsman said that I have no jurisdiction to decide. The law says the ombudsman is the appellate authority.
He should have heard this
He
matter.
should have heard this matter on merit.
all right this writ petition has been filed by the petitioner challenging the order dated so and so in the କୋଉଠି ଇଏ କରିଛନ୍ତି annexure କେତେ ସେଟା in the impugned order passed by the ombudsman it has been held taking into account the provision under section 40 bracket 6 of the Electricity Act 2003. That the petitioner has to approach the appropriate authority for appropriate relief and interim relief as prayed for. Since as a consumer in accordance with OERC distribution bracket condition of supply code 2019, the direction to the TPCODL not to provide the power supply to the to Soma Bhuiya ki opposite party number 7. Opposite party number 7 is not entertainable before the OERC. The London Council for the petitioner, so also the London Council for the opposite parties number 1 to 4 and opposite party number 7 submit that the ombudsman had got the necessary jurisdiction to adjudicate the matter and therefore referring to section 42(6) of the Electricity Act 2003, he should not have asked the petitioner to approach the appropriate authority. After going through the pleadings, hearing the Land Council for the respective parties and the consent of both the all the parties, the matter is remanded to the ombudsman OERC to adjudicate the petition filed by the petitioner, which has been registered as CR number so and so in accordance with law on merits. Accordingly, the petition is disposed of. जो आगुर लिखुଥିଲେ ସେଟା କାଟି ଯାଇଛି ଯୋଉ କାମ ସେଟା କାଟି ହେଲା କେତେ ନମ୍ବର ଏଟା ଗଲେ
Ombudsman is OP number 5.
ହଁ opposite party number 5 गले okay start clause on date shall be maintained till the till any order is passed by this one. So yes,
Grateful.
Yes.
Item 18.
The other day, your lordship posed a question regarding the appeal before the appellate tribunal and what steps were taken by the present petitioner there. So far,
About the status of the appeal.
my lord, the defects pointed out, the documents were filed, and on that day, the appellate tribunal directed the registry to verify the documents, and it has been posted to 19th January. Thereafter, the matter will be taken up. So the defect, so far the defect is concerned, I have complied.
19th January.
19th January.
Will this it up 19th? Will it up 19th?
My lord, my instructions are, my lord, defects have not been removed. Your lordship may record that, but here
record all the defects which have been shown has been stated to have been removed, and the matter is now fixed to 19th January. So this matter be placed thereafter.
Yes, ma'am.
Another thing, my lord, I'm taking note of. My friend has another counter affidavit in response to which I am filing my response. That means getting it.
Yun to आपको and your copy has been served.
Reply to the additional affidavit. Reply to the additional affidavit.
Objection to
Mr. Sorochandra Mahapatul and senior advocate appearing for the petitioner submits that the defects which you have pointed out in the before the appellate authority have already been removed, and the matter is fixed to 19/1/2026. So he has also filed an objection affidavit to the additional affidavit dated 29/11/2025 filed by the opposite party. Copy of the same has already been served on Mr. Gopal Agrawal and senior advocate appearing for the enforcement directorate with Mr. Jagyam Prakash Parida advocate. The objection affidavit is taken on record. ଏଟାକୁ କେବେ ରଖିବ ତ କ୍ୟାଲେଣ୍ଡର ଅଛି ଏଇ ଯୋଉ ତାଙ୍କୁ ଦେଇଛନ୍ତି ଯୋଉ ଡେଟ୍ କହିବେ ଆପଣ ଦେଖନ୍ତୁ 19 ତାରିଖ ପରେ କୋଉ ଡେଟ୍ ଦି ଜଣ ଯାକ କହିଲେ ରଖିଦବା ଆଉ that should be on a Monday or Wednesday or a Friday.
Whether your lordship wants to take up this matter in this year or
January means next year.
And put that question.
No.
30th January. Beyond that, before that, he will take all vacations are there.
Please tell us a date and give that date too on consensus. Mr. Agrawal, please see
any
that.
date, my lord, I have no objection. Any date.
So the rest of the matter will take up on this.
Any date convenient to my senior.
Give the date so that.
What about this number 19? This requisites speed post 18 not filed. Who is the counsel? Item. हाँ जी 21 तारीख पे जाओ 21st January 2026. Item number 19 or Pita Mahapatra. Madam, you have not filed the speed post requisite.
Today only during the course of
What is your good name?
Pragyan Pandya.
Ms. Pragyan Pandal and counsel submits that during course of the day, the requisites for issuance of notice to opposite party number so and so by speed court with a due will be filed. If it is filed today, the same shall be accepted and registry shall proceed. Yes, that's what.
My lord, item 43, my lord.
The wife of the petitioner minor is suffering from thalassemia.
Quickly, Delhi. Second up, item number 1.
Yes, I am appearing on behalf of my senior Mr. Manas Chandela. I am permitted to place motions. Worships, this is an appeal assailing the conviction of section 32VA of the SC/ST Act, read with 506 and POXO, section 6 of the POXO Act. The appellant has been convicted to undergo life imprisonment and 20 years for
Also the court reform notice to be issued. No. What is the topic? Yes, next.
Item 4.
Convicted under section 498A and 302, 304 part B of the IPC and read the section 4 of the DP Act. Punishment of rigorous imprisonment life or other offences.
Admit also interim application for bail in sterilization account to be considered.
I have obtained the custody certificate. I have obtained the custody certificate and conduct.
The Grand Council for the petition state produce the custody certificate and conduct certificate, which is taken on record. Yes, next. The petition copy to be supplied.
Item 3.
Item 3, Lordship. Appellants have been convicted and sentenced for array of life, Lordship, along fine, Lordship. And the case is under 302 and 34 IPC. The allegations,
there is no delay.
No delay.
IA number 2935 of 25 is an application for combination of delay. Since the stamp protocol has pointed out that there is no delay in filing the criminal appeal, the Grand Council for the appellant doesn't want to place this application. Accordingly, it is disclosed of us not best order meet for the trial for reform, but so some.
I left the custody certificate and conduct. I have already.
I am filing a certificate copy of the deposition, Lordship.
Deposition copies. No, you are giving.
Yes,
we do not require. It will come.
I am submitting a copy of the state.
The deposition supply also. That will be taken up for the receipt of the trial court for consideration of the case.
Item 4.
Item 4 that the appellant is convicted under section 376 DA of IPC and section 6 of POXO manner. I filed an IA for sterilization of fine and for bail also.
For the trial court reform. Notice to go. Interim application for sponsors shall be considered after receipt of the trial court report. The position to be suppressed. Yes.
Item 5.
We don't doesn't want to place this application. Exposed of us. Yes.
Item 6.
6, this honorable court directed me to obtain the custody certificate and conduct. I have obtained. So far as CA is concerned, I could not get it, my lord. I have already intimated SP, my lord. 13 years, 1 month, and 29 days in custody.
Your application was earlier rejected or first time? So, case under eyewitnesses are there?
No. Who is stated to be eyewitness is not there.
How many murders?
Single man. Disclosure statement.
You are the husband of that.
It's only disclosure.
Disclosure statement pursuant to the recovery of an ex.
Cause of death is?
Assault by
who is the doctor?
Dr. My lord, PW8 is the method. Cause of death is due to hemorrhage and asphyxia. Five incised wounds.
How many years after marriage this? When the marriage took place?
There's 4 children, and the elder is 12 years old. That makes marriage prior.
Heard the London Council for the London Amicus Skill and the London Council for the State. London Council for the State has produced the custody certificate of the petitioner. It shows that he is in period of detention than 13 years. And he has also produced the jail conduct certificate. He shows it to be satisfactory. The documents produced by the Land Council for the state are taken on record. Mr. Iwood Land Council for the apparent submits that it's a case based on circumstantial evidence, and there are good chances of success in the case. And since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Land Council for the state is the evidence of the doctor PW8 conducted post-mortem examination and would find that the cause of death was due to hemorrhage and asphyxia. There is no history, number of incised wounds on the deceased. So the wife of the appellant and gave his opinion that the injuries sustained by the deceased have been possible by the tangia of the arts. Tangia, the bracket legend MO1, which was produced by the investigating officer. And at the instance of the petitioner, he said Tangia was recovered.
Yes.
Considering the submission made by the Land Council for the restricted topic, absence of any direct evidence, nature of circumstantial evidence on record, and for the taking into account the period of detention of general. in judicial custody, jail conduct, and absence of any chance of abuse, we are inclined to release the petitioner on bail. It is allowed and communicate the order to the penalty. High Court prestigious proceedings, and it will also be sent to the jail superintendent, concerned jail superintendent. Yes. Brief.
Item 7.
Obtain the custody certificate, conduct and seal.
Yes, 5 months. 5 years, 5 months, 28 days.
What is the case?
Yes, PW9 is the eyewitness in the informant as well as the PW7 is the wife of the informant. Deceased.
How many eyewitnesses are there?
PWs 3, 4, 5, and 7.
3, 5, 7, 11.
3, 5, 7,
7
3, 5, 7, 11.
7, 11.
Doctor
Doctor PW8.
Doctor PW8.
PM doctor.
PM
Yes,
doctor.
The eyewitness person.
PW7 the informant. Informant is the wife of the deceased. And the informant in this case, my husband. House of the accused is our neighbor. He used to quarrel with the quarrel and abuse my husband and create gondogol with my family. On 10/6/2020, accused Govinda called my husband and told me that he would construct a house on his vacant land, which was in front of our house, and would take Nala through our house. My husband, however, refused to let him take Nala through our house. On that, accused Govinda got enraged and started abusing my husband. The accused also threatened my husband that in that night he would kill him, telling that if he lived, then he would obstruct his taking Nala through his house. Hearing the commotion, I came out of the house and brought my husband back to our house. Sometime later, my husband went to Government Hospital Jaipur as a relative of our house admitted for delivery. My husband returned at about 3:30 p.m. While my husband was absent, accused has come to our body side and he was saying that he would kill my husband, whose nickname is Munuratha. About 4 p.m., the accused came near our house and started challenging my husband. Unable to tolerate the abuse or let him by accused, my husband came downstairs and followed him. I followed him. My husband opened the gate of our house and the accused who had been at the gate for our house stabbed my husband by means of a knife on his chest, mid belly and lower belly. My husband sustained severe bleeding injuries and he moved a little ahead and fell down under a pomegranate tree.
So number of stab wounds are there.
On the right chest, that is on the right chest is
February 2026. Next. Next.
Item 8.
Item 8 has filed an application for bail on last occasion order dated 3/12/25. Lordship is directed to produce.
Nothing else.
After remaining, how many years you are granted bail?
Previously, I was granted bail on 21/2025 And
that was after how many years?
after 7 years. Sorry, my lord, after 8.5 years. And then again, now at present, I am in the custody for 9 years, 7 months, 20 days.
Where is that custody certificate?
Custody certificate.
Earlier it was there.
Yes,
No,
as on 6/4/2023, 10
that is 8 years, 9
months one.
Now he has that is dated केब्बे करेगा तिला?
24.
No, not 24.
The custody certificate was dated. Right, he's 24. केब्बे करेगा?
It was 2012, 2022.
2020, yes, sir.
2012.
And now, on last occasion, your lordship has directed to produce custody certificate from.
So 9 years he has remained more than that.
I am having an update.
Yes.
Yesterday, I received from the jail authority through WhatsApp. I will only show you.
You have get it signed. Put your signature here. Yeah. Land counsel for the petitioner, land counsel for the state. As for the previous order dated 3/12/2025, the land counsel for the state has produced the written instruction from the superintendent in charge of Central Police Station that there was nothing adverse reported against the petitioner during the interim bail period. Land counsel for the petitioner submitted that the petitioner is custody, judicial custody for more than 9 years and 7 months, and there is no chance of early hearing of the appeal in the near future, and therefore the bail application may be favorably considered. Land counsel for the state opposed the prayer for bail. There are eyewitnesses on the
Yes, ma'am. PW2, PW2, 3, and in cross-examination, they have brought out oral documents.
The PW2 and PW3 are the eyewitnesses to the occurrence, and Dr. K.
PW6, ma'am.
And PW6 is the doctor who conducted post-mortem examination and opined that the
Deceased sustained 12 injuries out of
what
that.
about the cause of death?
Cause of death is, my lord, profuse bleeding from the injuries. 5 injuries are grievous in nature.
No, food lekha is the cause of death.
PW2 is not the eyewitness, man.
Notice number of injuries and the person of the deceased, which could have been caused by someone.
Cross-examination, para 4. All the injuries confined to limbs. Death occurred due to profuse bleeding from the injury.
And stated that the death occurred due to profuse bleeding from the has not flouted the terms and conditions and absence of any chance of early hearing, we are inclined to the petitioner on bail allowed. Same for the communicate to you. We don't take on the code.
Item 9.
9 percent. She was confirmed.
Yes. Eight years, 7 months. Our criminal antecedent for Islam.
Madam, there is an antecedent. Is here. Involved in.
ଦଉନାହାନ୍ତି ସେଟା
This is.
ନାଇଁ କଣ ଗୋଟେ କଣ ଦଉଛି ଏଇଟାକୁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଏଇଟା କଣ ଦଉଛି ଆଚ୍ଛା there is one case is there P41 294 323 506
Public 447.
jail conduct normal ଅଛି what is the case 302
Yes.
eyewitnesses are there
There is PW 2 and 4, madam. PW 2 and 4.
PW 2 and 4 eyewitnesses who is the doctor
Dr. Myland, PW 11.
2 number ସାକ୍ଷୀ ପଳାଇଥିଲେ ଅଛି ତ ଆପଣଙ୍କର ଡିପୋଜିସନ ପଢନ୍ତୁ 2 number ସାକ୍ଷୀ
The informant is the uncle of my husband. The accused is the son of the elder brother of my father-in-law. The occurrence took place on 19/3/2017 in our house at 9 a.m. In our house, we are staying in a common dwelling house with family of the accused persons. The deceased Satyasundar Kono came to the dining room and asked for food.
now how did he decide to this
Madam, there is.
to PW2 are related
Yes, madam.
କଣ ହବ
Cousin brother.
PW2 ର cousin brother ହବ deceased
Both deceased and were killed.
okay ହଁ ପଢନ୍ତୁ
The deceased Satyasundar Kumar came to the dining room and asked for food, but I was inside the bathroom, which is adjacent to the dining room. So I remained silent. At that time, Satyabhama Ratha was inside the kitchen and preparing food. On being directed by Satyabhama, he himself served the food and bring the food at the dining hall. All on a sudden, he shouted by saying, "Bolo bolo morigali." I immediately opened the door of the bathroom and I found the accused overpowered the deceased and the deceased fell on the ground and the accused was stabbing him with a knife. At that time, Satyabhama requesting the accused to leave him. Although she, along with the mother of the accused, tried to intervene, but the accused was not in a mood to listen them, and due to continuous assault of the accused, I found the deceased was lying in the blood. I raised Holla and the nearby inhabitants rushed to the spot. And on their arrival, the accused ran towards a room and locked inside the room.
11 number କୁ ଆସ
It was 97. On 19/3/2017, I was working in my present post. That day, on police requisition, I conducted postmortem examination over the deceased Satyasundar Kumar, son of Chandrasekhar.
you have been released on bail
No.
no are the land council for the petitioner land council for the state the land council for the state has produced the custody certificate which shows that the petitioner is in judicial custody for more than 8 years 8 months the custody certificate is taken on top of we have also produced the report regarding the jail conduct which it is normal however there is one criminal antecedent against the petitioner which is of the year 2015 for magistrate tribal officers the written instruction produced by the land council for the state taken on the top the land council for the petitioner submits that in view of the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, the bail application of the petitioner may be favorably considered. And counsel for the state, on the other hand, oppose the prayer for bail and submit that PW2 and PW4 are the two eyewitnesses who have stated about the appellant giving knife blows to the deceased, and PW11 is the doctor who conducted post-mortem examination and noticed number of stab wounds on the deceased, and opined that the cause of death was due to shock and hemorrhage. Considering the submission made by the land counsel for the respective parties, in view of the evidence of the eyewitnesses coupled with the medical evidence, were not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, we are inclined to release on interim bail for a period of 3 months. While an interim bail, the petitioner shall not indulge in criminal activities, shall not try to come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation. Yes.
No question.
Order to be communicated.
Item 10.
My Lord, Judge prevailed, item number 120, 2025. Offense committed only 302 of IPC. Correct.
Only 302. Can I have छुट्टी happens only 302.
2 and 4 were eyewitness were declared hostile.
Eyewitness की है?
2 and 4 were but they are declared hostile.
2 and 4. Hostile. How कौन अच्छी?
PW15 is the doctor to be.
PW15 doctor.
Doctor, are you
Our evidence कौन अच्छी?
Order 2 and 4 hostile coaching.
এটা আমি শুনি স্যার লুনিছে কইলেন ଆଉ কোন ଅଛି
period 1 কিন্তু post of
কি কোন কইলা According I found that my nephew was lying dead. So and so committed murder. So and so. He came afterwards from. If your eyewitness has not supported the prosecution case, then your case must be based on some circumstantial evidence to establish. Of course, the doctor would say that it's a homicidal death, but you further prove that the appellant is the author of the crime, and your eyewitnesses are not there; they are not supporting. So, how will you establish this guilt of the accused? Eyewitness was present. Are the land counsel for the petition, land counsel for the state? The land counsel for the state has produced the custody certificate. The petition shows that the petition is in judicial custody for more than 10 years. Has also produced এটা जो केस यही चाहिए यही केस था 302 रो that he has no criminal antecedent and his jail conduct is good. The certificates are taken on record. The land counsel for the petition was submitted that though the prosecution examined PW2 and PW4 as the eyewitnesses to the occurrence, but both of them didn't. Fourth hostile reading. I know not know the accuser. PW4 eyewitness will keep along. He has not been declared hostile, but he has not stated that accused is the. That on the date of our night, deceased was sleeping. I have looked for room, so and so. The door was about at night. A boy and my nephew, whose name I do not recollect, came to and called me. I said, "On my son was lying dead." He so and so. Information. He is not an eyewitness. Who is an eyewitness? Not supported. Look, PW2 is an eyewitness to the occurrence. Didn't support the prosecution too. And therefore, and there is no other clinching circumstantial evidence on record for upholding the conviction of the petitioner. And since there is no chance of early hearing of the appeal, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail pays the evidence of the Dr. PW15 who has noticed number of chop wounds on different parts of the body of the deceased and opined that those injuries are antemortem in nature and sufficient ordinary course of nature to cause death. And that death was due to shock as a result of hemorrhage due to the injuries sustained. And considering the submission made by the learned counsel for the respective party, since the eyewitness to the occurrence has not supported the prosecution case, and sense of any other clinching evidence on record, taking into account the period of detention of the petitioner, the injuries as custody, in absence of any chance of early hearing, and further taking into account the period of detention, we are inclined to release the petitioner on bail. Yes.
Item 11.
That custody certificate and appellant's age at flag C, my lord.
Custody certificate is 4 years, 9 months.
The appellant's age, my lord. So the appellant's age also, my lord, they are in flag C. Flag C.
For 73 years,
my lord. And the my lord,
the 302 case.
My lord. And the case is based on, my lord, circumstantial evidence. And circumstances like one is motive, and another is intention, and third is recovery of weapon of offense. That is at page number 23, judgment 24.
So far as concerned, there well of this submitted the Aadhaar card. But so far date of birth is concerned 15 to 1961.
ସତୁରି କେମିତି ଆପଣ ଏଇଟା କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଲେଖି ଦଉଥିଲେ?
ଜଜମେଣ୍ଟରେ ମଧ୍ୟ ଲେଖା ହେଇଛି
73। ଆପଣଙ୍କର ଆଧାର କାର୍ଡ ଅନୁଯାୟୀ ଆପଣଙ୍କର ଏଜ ହଉଛି ଡେଟ୍ ଅଫ ବାର୍ଥ ହଉଛି 15/2/1961। ହେଇନି 70।
Total judgment is mentioned, that's why
ठीक है, but might have been some ସେ ଗ୍ରାଉଣ୍ଡରେ ଆପଣଙ୍କୁ ବେଲ୍ ମିଳିବନି।
My lord,
ବାକି
other aspects I will submit, my lord.
ଅନ୍ୟ କୌଣସି କଣ
My lord, the case is based on circumstantial evidence.
କୋଉ circumstance ଗୁଡାକ
Circumstance is page number 24 in judgment. One is motive.
internal phase
In judgment, internal phase, page
हाँ।
24.
paragraph number 9
Paragraph above 9, my lord. 8 ର last part, my lord. One is motive and another is intention.
You come to the internal page of the judgment,
My lord, 24.
24 तो 24 ରେ middle ରେ ଲେଖା ହେଇଛି arguments of the defense,
Arguments of the just above that, arguments of the defense.
ତାର କେତେ ଲାଇନ ଉପରକୁ କହୁନାହାନ୍ତି?
1, 2, 3.
Thus the evidence proves the motive was there.
Thus the evidence proves that the motive was there and the intention to kill the victim was there and seizure of weapon of offense. That and here my
eyewitness admittedly nahanti.
No, my lord. And one more thing, my lord.
Spade मिलला आपनको.
Spade मिलला, my lord.
Motive थिला माने
motive described in page number 23 middle part re, because there was serious land dispute between them. In page number 23 para number 8 IV, Roman IV. The land dispute thila setilagi that happens. And above all, my lord, there are altogether 22 witnesses. Out of 22, BW 6 to 15 turned hostile. Who were present over that cultivation lands at that time. They turned hostile. And PW 5 is the informant. And PW.
So 18 circumstances.
My lord. And one more thing, my lord. That is, recovery of spade is there, but there might be another offensive weapon is there. That is hololongalo. That is in term Odia. That this happens maybe in that.
IA number 355 of 2025. There is an application for bail. So the learned counsel for the petitioner has taken a ground that the petitioner is aged about 73 years, which is also mentioned in the trial for judgment. However, the learned counsel has produced a copy of the Aadhaar card of the petitioner, which shows that the date of birth of the petitioner is 15 to 1961.
Charge sheet is 1963.
However, in the charge sheet, it is mentioned that the date of birth is
date of year is 1963.
1963. Be that as it may, since the entry in the Aadhaar card indicates that the petitioner has not attended 70 years. Therefore, the ground, the bail cannot be granted on that ground. However, the learned counsel for the learned counsel for the petitioner submits that the case is based on circumstantial evidence, and circumstances have been mentioned in the judgment that there was motive behind the commission of crime, and there was intention of on the part of the petitioner to kill the deceased, and one spade, which is the weapon of offense, was seized at the instance of the appellant, and which makes the chain complete. The learned counsel for the petitioner submits that there was some land dispute between the parties, and the report is present?
No, my lord, that forensic report is available.
The spade has been seized, but there is no FSL report to show that there was blood on the spade, which which correlated to the deceased. It is further submits that of the material available on record, there are good chances of success in the appeal, and since balance of convenience is in favor of the petitioner, the bail application may be favorably considered. When counsel for the state, however, oppose the prayer for bail and place the evidence of the witnesses, considering the submission made by the land counsel for the respective parties in view of the evidence on reform, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention, absence of any criminal antecedent against him, and also his behavior inside the jail, it have liquid conduct certificate. We are inclined to release the petitioner on bail for a period of 3 months. Yes, next. Fine state. Fine state. Fine state.
Item 12.
May please, your lordship. My lord, order dated 1/12/2025, your lordship was pleased to call for the custody 1712 of 2025. That order was passed. And 1/12/2024.
What about the date of appellant number 2? Limousine. There was an order passed.
Yes, I. That order, my lord, 1/12/2025 order already.
The custodian bill.
Yes.
Paragraph 3 of your lordship's order.
On the paragraph.
Yeah, that to observation that already died and no legal.
Oh, it is awaited.
That order was there.
Oh, that is already awaited.
Since no legal hair on top of it.
Who is awaited?
So this is only for appellant number 1 and 3.
1 and 3 man.
One of custody certificate.
Only is part of them.
But these only are 16 years লেখা হয়েছিল মুন্না আলিয়াস অন্তর্যামী অন্তর্যামী ক্ষেত্রে appellant number 1.
He was arrested on 9/2/2010.
Is it a double murder case?
No, my lord, single murder and another injured. So direct she was injured, and my lord, another husband, my lord.
Eyewitnesses are there.
Yes, my lord.
Single murder.
Single murder, but eyewitnesses stated the role played by the Bhima, who has already been died, not by this present petitioner. If your lordship will kind of a glance to the judgment
for the petitioner. Ketha reject is the learned counsel for the petitioner submits. Now, as per the previous order dated so and so, the land counsel for the petitioner, the state has produced the custody certificate, which shows that the appellant number 1 also has remained in custody for so and so period, and appellant number 2 has remained in custody for so and so. He has also produced the jail conduct, which shows that there is nothing adverse against the petitioner. The custody certificate and the jail conduct are taken on record. Land counsel submits that in view of the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, the bail application may be favorably considered. Land counsel for the on the other hand approach is there for bail submitted that there are eyewitnesses to the crime. That and the doctor's evidence. Doctor K,
PW 11 madam.
And the doctor's evidence over the evidence of the eyewitnesses and the doctor has stated that cause of death was due to shock as a result of injury due to the fell out unlike considering the submission made by the Grand Council for the respective parties. Period of detention of the petitioner of judicial custody and absence of any chance of further hearing. We are inclined to release the petitioner bail allowed and his jail conduct will be. Yes. Bless.
Item 13.
May I present? And the reply to the objection.
Hmm. 14 years left on.
14 years, more than 14 years.
And there is CA also. Is able to Potamandi PS case number 3.
Inter election the case.
No.
Inter Gote Hochi 302 said a case.
Second.
Just a minute. It was Kendrapada town PS case number 106 of 97. You judgment का जो impugn judgment.
No. PS case 124 of 12/6/11. B2.
कौन पचार लोग हम पचार जो criminal antecedent रे गोटे case अच्छी सेटा यही केस ना आउ गोटे 302 केस
एटा सेकंड एटा फैक्ट एटा एक्यूटेड
एटा जो पटामुंडी केस
पटामुंडी रो जी नंबर 2 टा
नंबर 2 दिस केस
नंबर 3 टा होजी 302 आउ गोटे केस एटा होजी 97 एटा कोन हला
एक्यूटेड
काई फुल इलेक्शन
in whole exam I have written that I am acquitted in all cases
Udi.
in para 11 the applicant that no other criminal cases pending against him. In earlier cases, he has been acquitted by the honorable court.
So, where is the judgment?
So, my lord, some difficulty is there. The appellant is inside the custody, and her wife is not well. So, I am very difficult to.
How can we know that? Is it?
State maybe.
You say no, it's not another offense. It is another 302 card. And say you 302 re, upon bail thila bade, I would 302 version.
No.
If you have been acquitted, so we want to, you are not giving the judgment.
And there is also Potamandi case number 60. 307 is there.
Hold on.
Time may be given child files. Time will be because wife is not able to connect.
All right. This case arises out of this case arises out of Patamundi case number 124, dated 12/6/2011. The Learning Council for the state has produced study certificate, the jail conduct, as well as the criminal antecedents against the petitioner, which shows that apart from Patamundi PS case number 124 of 2011. There are two other cases. That is Patamundi PS case number 60 of 2011 under section 307 IPC and other offences. Mount PS case number 106 of 1997 under section 302 of IPC and section 25 and 27 of the Arms Act.
And 9B
and 9B of the Indian Explosives Act. The learned counsel for the petitioner has filed an objection to the additional affidavit filed by the state, wherein in paragraph number 11, it has been mentioned that the petitioner has been acquitted in other cases except the present one. However, the judgment of acquittal has not been filed. Learned counsel for the petitioner seeks some time to produce the certified copy of the judgments in Patamundi PS case number 60 of 2011 and Kendrapada Town PS case number 106 of 1997. It is this matter, second week of January 2026.
Item 14.
Report. Certificate and the
चारि पांच छह पांच केते दिन होची केते वर्ष केते मास
12 years 6 months. 5 days.
12 years
12 years 6 months 5 days.
6 months. ଆଉ जेल कंडक्ट तो ठीक अछि बाकी एंटीसीडेंट कुछ नाही
No, there is no accident.
अच्छा कौन अछि तो केस रे
PW180 I used to work as
सब रिजेक्ट हितला
this will face. PW1 mega.
रूम नो आगु रिजेक्ट हितला तो तीन तर होजन
Yes.
अच्छा दुई अच्छा interim bail के बजाय थे
No matter.
Heard the learned counsel for the petitioner and counsel for the state. The learned counsel for the state has produced the written instruction received from the officer in charge of Kanjipani Police Station, Kyongja, which shows that there is no criminal antecedent against this petitioner. He has also produced the written instruction received from the superintendent district jail Kyongja that the data point that the jail conduct is satisfactory, and he has also produced the custody certificate This shows that the petitioner is in custody for 12 years and 6 months. All the documents are taken on record. The Land and Council for the state submitted that the bail application of the petitioner was rejected earlier thrice by this court. Once on 19/2019 and then 18/4/2022. And also on 9/1/25. In view of the available material on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 12 years and 6 months, and absence of any chance of early hearing, and keeping in view the case of Lekki versus Wansh, 3 months bail granted. Yes, lucky date fix of further surrender certificate.
Item 15.
On the last occasion, my instruction was cut for the mother of the parents is serious. The mother of appellant serial number 799 of 2019. Or mother's illness was that interim bill I have filed.
The mother Chagala Sundar is having 50-year-old and now she is ଭଲ ଅଛି ତ କିଛି ନାହିଁ ଅସୁବିଧା ନାହିଁ କୋଉଠି ପାଇଲେ କଣ ମା ବୟସ ଲେଖା ହେଇଛି 58 ବର୍ଷ
59 years.
ସ୍ୱାମୀ ଅଛନ୍ତି ବଡ ପୁଅ ଅଛି ସେମାନେ ତାର ଯତ୍ନ ନଉଛନ୍ତି ଅସୁବିଧା କଣ
custody ଅଛି
that's a matter on merit but you are pressing for an interim application on the ground of health condition so that cannot be granted on this ଲେଖି ଦିଅନ୍ତୁ IN number କେତେ number ସେଟା
272
ହଁ
ଏଟା number
ଆପଣଙ୍କର ଇଏ କେତେ number criminal appeal number କେତେ
799
799 ମାନେ
IN number 2927
ଦେଖନ୍ତୁ CRLA number 799 of 2019 IN number ହଉଛି 2927
ଆଜ୍ଞା
2927 of 2025 is an application for interim bail on the mother as per the last order dated 3/12/2025. The Land and Council for the state has produced the report of inspector in charge of Hon'Ble police station, which shows that though there is no criminal antecedent against the petitioner, but his mother is aged about 58 years and she is in the house and her husband as well as her elder son are taking her care. In view of such a report furnished with Land and Council state, and since no medical document has been annexed to the interim application in support of the element of the mother of the petitioner, we are not inclined to release the petitioner on interim bail. So IA Tahala 2927 Tahala rejected. Now merit person.
More than 8 years and 8 months of custody 376D. Birth certificate mobile last topic.
Birth certificate are there now. Another. ये सब केस रे नहीं आइजन तो ସବୁଥିରେ ତ ବେଲ୍ ଫାଇଲ ହେଇଛି ନା ଏ ଯୋଉ ତିନିଟା criminal appeal ଅଛି in each case there is one appellant or more than that
one appellant
ସବୁଥିରେ ଗୋଟେ ଗୋଟେ
ଆଜ୍ଞା
ସବୁଥିରେ ଗୋଟେ ଗୋଟେ।
You are placing which application?
ବୋଲେ 2928 ମାନେ serial number 799 of 19.
799.
Yes, sir.
and who is there in 718?
718. I am sure for the applicant on behalf of Mr.
You want adjournment?
That's
Your good name?
Pankaj Kumar Sahu.
Pankaj Kumar Sahu. Ladies and CRL number 718 of 2018. Mr. Pankaj Kumar Sahu and counsel appearing for the appellant submits that he is an associate of Mr. Amit Kumar Nath and he wants adjournment. Is this matter after Xmas holidays? Now, बाकी which is second house 85 of 2019. You are there. आनी ना नहीं?
and both criminal antecedent and custody certificate.
Custody certificate देखौची 8 वर्ष या ना होची कृष्णचंद्र ठीक अछि
85.
बाकी एटा होची
चगला एनएस डिसेंबर
बुझुन ना आर क्रिमिनल एंटिटी नहीं ये जो लोकटार गालिया ଗୋଟେ ତ ଦେଇଛନ୍ତି ଏଇଟା ତ ଆର ଯୋଉଟା ଆମେ ଏଇଟା ନା ଏଇଟା କାଳିଆ ଏଇଟା ହଉଛି ଚଗଲା ଏଇଟା ନୁହେଁ ଏଇଟା ଅଲଗା ଏଇଟା ହଉଛି ନେକ୍ସଟ ଆଇଟମ କାଳିଆର ଇଏଟା ଦରକାର କାଳିଆ କୃଷ୍ଣ ନାୟକ କାଳିଆ alias Krishnachandra Nayak. We want the criminal antecedent and also the jail conduct. Day after tomorrow. ଆପଣଙ୍କର ସବୁ ଏତିକ ଜେଲ ତା ଦେହରେ ତାଙ୍କର ସେ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କର ଇଏ ଥିବ ନା ଇମେଲ ଥିବ ତ ଗୋଟେ ଫର୍ମାଟ କରିଦଉନାହାନ୍ତି ଯୋଉ କେସ୍ ଆମର ଇଏ ରହୁଛି କ୍ରିମିନାଲ ଅପିଲ ନମ୍ବର 1 ପହଞ୍ଚିଲା ସିଏ ଆପଣଙ୍କୁ ରିପ୍ଲାଏ ବି ଇମେଲରେ ଦେଇଦେବେ ସେଗୁଡାକ ଆଣିକି ପ୍ରଡ୍ୟୁସ କରିବେ ହଁ it's very easy ଆଜିକାଲିକା and if you have got the connection with all the authority jail authorities including your that open jail जोटा अच्छी it would be easier ଆଉ ये ଗୋଟେ ଥର ଆପଣ ଆଣିବେ ଖାଲି jail conduct ତାପରେ ପୁଣି ଆଉ ରହିଗଲା ଲେଖନ୍ତୁ जो CRL number 85 of 2019 Learning Council for the state has produced the custody certificate. However, it took some time to obtain instruction regarding criminal and jail conduct of the appellant as per the previous order dated 3/12/2025. This matter କେବେ ଆଣିବେ ବୁଧବାର next ବୁଧବାର ମାନେ day after tomorrow ବୁଧବାର day after this matter on 17th.
Next item,
Data next item.
serial number 799 of 9.
Sure. All the matter day after tomorrow. All the matter day. Yes, yes. It will like too. Other ये custody slip ଅଛି ତ
last time ଦେଇଥିଲି ଏଟା
it was 17 12 ତାପରେ ହଁ B 799 17 ନା ୟାର ହାର୍ଟଟା ଦେଖେଇଲା ଯୋଉଟା 799 କଣ କହୁଛନ୍ତି ଜେଲ ଆସି ଯାଇଥିଲା ବେଳକୁ ୟା ଦେହରେ ତ ଆମେ ନା ପାଉନି ସେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କୋଉଠି ଦେଇଛନ୍ତି
ବଢେଇଥିଲେ ଫାଷ୍ଟ ମିଶିଗଲେ
ଡିରେକ୍ଟର ତୁମର ତା
ତା ଦେହରେ ଲେଖିଦେବେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଇଏ ତିନିଟା ପ୍ରବେଶ କରିବ ୟେସ୍ ନେକ୍ସଟ
Item 16.
custodian
appearing on behalf of Mr. Tripathi is a case where justice hurried has become justice violation. POCSO Act, notice, what about notice? Notice is sufficient. Second week January Yes, next.
Item 17.
Six, some time to obtain instruction relating to the conduct of the petitioner on interim bail. अब बाकी custody certificate
Not up.
Nice. And also obtain the custody certificate.
Jail conduct.
So dita near asantu. Conduct during interim bail, है ना? अब बाकी वाला जो custody certificate, हाँ? After next,
Next, my lord, similar situated two of the appellants, my lord, granted bail to them. And petition also stands on similar to them. After judgment, 6 years, near about 7 years, my lord.
Sign on.
Sign on. After on your sarguru same matter.
no, ଆପଣ ଆଗରୁ bail ଯାଇନଥିଲେ interim bail?
ନାଇଁ ସେ ମଦର ମରିଥିଲା 21 ଦିନ ପାଇଁ ଯାଇଥିଲା 20 ମସିହାରେ 20 ମସିହା 7
ଓ ତାପରେ ଆଉ ଯାଇନାହାନ୍ତି?
ନା 20 ମସିହାରେ
ଆଚ୍ଛା, now you have filed your application is
bail
IN number 512 of 2024.
ଦିଟା ଗୋଟେ ସେମ୍
Same.
similar situated co-appellant also granted bail since they are custody 6 months.
ଏଇଟା custody କେତେ?
ମାନେ same ମାନେ
Yeah, bail ଥିଲେ after judgment taken in
custody
custody.
ସେବେଠୁ ରହିଛି
The two orders which has been passed in respect of co-appellant, they are released. Same supporting.
same
88/2019
Your Lordship referred the evidence of doctor as well as the evidence of PW3. Same identical.
injury only number 1 and 2 that is Prime Minister sword recover from the Kartik not the petitioners. What is the my client, my lord, Upendra alias Rupa Mahapatra.
ସିଏ ତ ଯୋଉ ଏଇ ଯୋଉ ଆମେ ତାକୁ ଦେଇଥିଲୁ 88 of 2019 ରେ ସେ ଫାଇଲ ଟା କାଇଁ ଆଜି ଲାଗିନି?
That's ଅଛି
88 ରେ ଥିଲା 6 ବର୍ଷ 9 ମାସ। ଏ ଲୋକ କେତେ ରହିଛି?
ଏ 6 ବର୍ଷ 11 ମାସ ହେଇଗଲା।
11 ମାସ ହେଇଯିବ ଆଉ ଟିକେ
2 ମାସ ପଡିବ।
ଆପଣ ଦେଖିଛନ୍ତି ଯୋଉ ଆପଣ ଦେଖି ଦିଅନ୍ତୁ ଏଟା ପହର ଦିନ ନେଇ ये जो दीटा बेल ऑर्डर देउछन से
कॉपी भी सर सो दैट
हाँ कॉपी हम तंग कॉपी दे दियो से सब the learned counsel for the petitioner Mr. Robert submits that the petitioner is in judicial custody for about 7 years and two of the co-appellants in the connected criminal appeals, that is CRLN number 88 of 2019 and CRLN number 419 of 2019, namely Udu alias Sarat Kumar Swain and Vishwanath Mahapatra, were directed to be released on bail by this court by order dated 22/10/2025. এটা পুরা বেল হয়েছে তো আচ্ছা the copies of the bail orders are filed. It is further argued that the petitioner is similarly situated. Let a copy of the bail orders be handed over to the learned counsel for the state for verification regarding the claim of parity put of this matter on 17th of December 2025.
Same order also in the criminal appeal 190 of 2009. Last appeal.
এটা সব একাটি আসিও পরদিন
The only difference, the difference 116 re. Sir, same thing has been happened as like 75. 116. Earlier he was 3
আগুর যাইছি ভারি
3 months.
তার আনিবে কন্ডক্ট তাহলে আনিবে
সেটা
এইটা কন্ডক্ট নিয়ে আসন্তু
116
ବାକି ଏଇ ଯୋଉ
କଷ୍ଟଡି
150 ଆଉ ଏଇଟା ଯୋଉ କଣ ତା ନା 109 150 ଆଉ 190 ଏଗୁଡାକ ସବୁ କନସିଡର ହବ
ସମାନ
75 may be considered on that.
Next.
With due respect, we have already handed over one set, maybe return back will immediately.
এটা কহিলেনি সেটাକୁ সিলটা মারা ও স্যার সিল মার দিয়েছি আচ্ছা
গোটে সেটটা
You can download numbers are there.
ଏଗୁଡାକ ଆଜିକାଲି ସବୁ ଏଥିରେ ଯାଉଛି ନା ଆମର ଆଭେଲେବୁଲ ଅଛି
You can take it. Yes. It is done.
Xerox କରିକି ଦେଇଦିଅ. Yes, next.
Item 18.
Yes, next week. Next week রাবনি এ জীব ছুটি পড়ো
ଆମେ custody ଆଉ conduct jail conduct
আচ্ছা the learned counsel for the state has produced the custody certificate how is jail conduct certificate which are taken on record Revatulata Panda learned counsel appearing for the alpha and 6 for an adjournment after Xmas holidays. Next.
Item 19.
Please, ma'am. Here I am in custody for 8 years, 2 months and 18 days.
Guru bill reject lagi.
Aguru reject I had gone to the Supreme Court. Honorable Supreme Court directed me to renew my prayer for bail if the appeal was not disposed of within 6 to 8 months. I have filed a copy of that order in IA 2330 of 25, page 7, 18-11-24.
In case appeal cannot be taken up for hearing for 6 to 8 months, we open for the petitioner to file a case.
This court, this order was brought to the notice of this court.
Yes.
When?
30/11/2024, the registry communicated the order of Apex Courts registry.
Paper book ତିଆରି ହେଇନି?
Paper book ତିଆରି ହେଇଯାଇଛି.
Have you received the copy of the paper book?
Yes, me.
What are the materials on
The case of dowry death. Death is due to burn injuries. My brothers and sisters have been acquitted. One brother and the husband, they have been convicted.
As it appears, 5 persons were facing.
Yes, 3 have been acquitted. Subhas Das, Sujata Das, and Santosh Das. Das.
Subhas is who?
Subhas is brother-in-law.
This is the brother-in-law. How? Sujata?
Sujata ଆଉ ସନ୍ତୋଷୀ ହେଲା sisters-in-law.
ଆଚ୍ଛା ସେମାନେ acquitted ହେଇଗଲେ।
ଆଜ୍ଞା ସେମାନେ married sisters।
ଆଚ୍ଛା ଯୋଉ ଦି ଜଣ ରହିଲେ ପୂର୍ଣ୍ଣ ଗଣେଶ ପୂର୍ଣ୍ଣ କିଏ ଗଣେଶ କିଏ?
ପୂର୍ଣ୍ଣ ହେଲା husband, ଗଣେଶ ହେଲା brother-in-law। ଗଣେଶ ହେଲା husband।
Ganesh is husband, Purna is brother-in-law.
Husband of the sister of sister.
बाकी on what basis the conviction order has been filed?
Your lordship may look at the judgment arrest is on 25/5/13।
22/5/2013 ଲେଖା ହେଇଛି paragraph 3 ରେ trial court judgment of paragraph 3 page number 3 ରେ ଲେଖା ହେଇଛି 22/5/2013। अच्छा ତାପରେ date କେବେ ହେଲା?
Death Millard says occurred on 23/9/17 in the intervening night of 23/9/22 and 23/9/17।
Any issue out of wedlock?
Yes, there is a child. Male child.
Cause of death, burn injury.
Burn injury. The lordship may look at the judgment, internal page 34. The court has observed at para 26. In the case at hand, it has already been found that Madhusmita was the wife of Purna and other accused are the relatives of Purna. Death of Madhusmita was due to extensive burn injuries of her body.
The other, Mr. Panda, the other charges were found not proved.
Miles.
Only 302 he was
Yes,
found.
498A, 304B and DP Act.
So, no eyewitness.
No.
And on what basis?
Basis will not, because I am the husband and she is the wife. Death took place.
Ganesh ପାଇଁ କଣ ଅଛି?
Ganesh against who allegation ହଉଛି. Your lordship may look at page 38 of the brief.
38.
And that is at paragraph 29. The court writes about on the fourth line of that page 38. This is evident from the depositions of PW 7 and 10.
No, 38 38
internal page 38 of the judgment.
Judgment 38.
The sentence begins, even from the evidence of defense which 10 has stated that at about 7:30 p.m. of Baisino, he got information that his cousin had been killed. He immediately came to the house of her in-laws, found her dead body inside the bathroom from where the smell of kerosene was coming. It is in the evidence of PW5 that on Baisino, elder brother of accused Purna, namely accused Ganesh, scolded deceased in filthy language for having fascination for purchase of something. Above incident took place on the same date of the evening of Vaisino when death of Madhusmita occurred. These facts are to be treated as part of the same transaction, forming part of the res geste evidence. Therefore, the same is evidence. Admittedly, Purna and Ganesh are the occupants of the house. Dead body of deceased was found inside the house. Death of Madhusmita has been found homicidal, as has been held by the Honorable Apex Court in so and so, which has been relied on by the Honorable High Court in the case of such and such, which is cited by the learned PP. Appellants were identically placed over a duty to explain how a homicidal death happened in their house.
Homicidal death ର କଣ କେମିତି କହିଲେ? Burn injury ଟା?
Burn injury ଟାକୁ ଯୋଉ homicidal death ଟା କହିଲେ ସେଟା ହଉଛି 113B ଉପରେ
So maybe it may be also a suicide.
My lord, I am coming to the doctor's evidence.
Doctor P.S.
The PW 18.
ତାର discussion ହେଇଯିବ ନା?
ଆଜ୍ଞା।
କୋଉ paragraph?
Paragraph 10 ଦେଖନ୍ତୁ।
Paragraph 10.
Page 11 ରେ the foremost question that needs to be determined is whether the death of the deceased was homicidal in nature. 10, page 11.
Page 11 paragraph is in the background of the.
It would not be enough to record here that both DWs 1 and 2 in their cross-examinations frankly speak their inability to say how the deceased received burn injuries. Most vital witnesses examined on behalf of the prosecution to throw light on this aspect are PWs 18 and 22. PWs 18 and 22 were medical officers of the DHH Paralakemundi on 23/9/17 when in the hospital postmortem. PW 18 has deposed that in the postmortem she found deep burn injuries over the medial aspect of left thigh, all along from groin of the left side to the medial aspect of left knee joint. Face was swollen and congested, eye semi-closed with frothy blood-stained fluid coming out from both the nostrils, mouth and hand clenched both sides, hair over left side of the head completely burned, and at the right side comparatively less burned. On dissection, it was found that mouth and pharynx contained congested dark brown frothy blood, and stomach contained semi-digested food materials, rice, and lungs congested, edematous, emphysema with copious frothy fluid, blood stains. Left side of the heart empty, right side dark brown blood, brain congested, cranium filled with dark brown blood. She has clearly deposed that injuries suffered by deceased were antemortem in nature and viscera contained no poison. She has opined that death of the deceased was caused due to burn injury resulting from shock. She has further stated that the extent of burn injury suffered was about 90%, which in ordinary course of nature is sufficient to cause death. The death of the deceased was caused due to burn injury resulting from shock. Eta efforts of due to shock resulting from burning. Evidence of PW 22 is alike PW 18. She has affirmed that the injuries suffered by deceased were antemortem. Death was caused due to 90% burn injury on a person.
What are those injuries?
It thyroid. There, page 11.
Left thigh.
Oh, she found deep burn injuries over the medial aspect of left thigh, all along from groin of the left side to the medial aspect of the left knee joint. And face swollen and congested, eyes semi-closed, frothy blood-stained fluid.
What is the period of custody of Ganesh?
8 years, 2 months and 18 days as of.
How do you find about the Ganesh case? The other man is husband and it's homicidal death finding.
Before that, I'll ask your lordships to look at the evidence of PW 18 which has been omitted. Paragraph 3 of the evidence.
18?
PW 18, the doctor who conducted postmortem. She has stated at paragraph 3, the last sentence, my lords may see,
I
cannot say whether the
I cannot
injury was
say-
accidental or
I-
self-implicated intense.
I pointed out that
There was no shoot present in the respiratory
That
tract.
part-
or-
that part was-
And this is the evidence which the trial judge has conveniently omitted.
Which one?
the last para 3.
Last sentence of para 3.
I cannot say whether the injury was accidental or self-implicated into itself.
What do you say about Ganesh?
I think that no specific is not read.
ये husband କଥା ଅଲଗା ये तारो स्त्री टा acquittal ହେଇଛି married sister in law ନା ये तारो husband ମାନେ non the
brother ବୋଲି deal କରିଛନ୍ତି କିନ୍ତୁ judgment.
ହଁ
Judgment ରେ deal ହେଇଛି brother ବୋଲି.
Incident ଗୋଟେ ଦିନ ଆଗରୁ ଖାଲି scolding କରିଥିଲା killing ରେ. That's the only
ସଂଖ୍ୟା କାହିଁକି
ସଂଖ୍ୟା କାହିଁକି? That's all. Nothing else.
no this man is
Ganesh has been granted bail. This court has granted bail to him.
Ganesh.
Aye.
Already.
Order dated 15/12/22.
so the only
Purna is the person.
yes
Okay.
so see how do you देखी in view of the order of the Honorable Supreme Court, we have to consider the bail application because it could not be disposed of within that period.
Friday.
We have to tomorrow. I am not.
Friday. Hey, custody certificate, jail conduct also produced.
The learned counsel for the state has produced the custody certificate. I would want jail conduct stuff which are taken on record. So Devashish Mandal and counsel for the petitioner has brought to the notice of the court the order dated 18/11/2024 passed by the Honorable Supreme Court in case of so and so, wherein it appears that to the bail application was dismissed. However, this court was requested to take up the appeal for hearing expeditiously. And in case the appeal could not be taken up for hearing within 6 to 8 months, it would be open to the petitioner to file a case application for suspension of sentence, which appeal which applications will be decided as per law. This order you have not filed.
No. We have filed along with the IA.
Also, this order along with the interim application.
And it has been communicated to the registry of this court on 30th of.
Which was filed on 20th August 2025. How do you find that it has been communicated to the registry?
Your Lordship may see the in the record. It has been. It's at page 112.
112.
Yes.
To assistant resident sponsor forwarded.
Note 19/9/2025 there is a note. Order dated so and so. Place so
That has been reflected in your Lordship's order.
Footer.
After note in the office note, right? Office note. Office note. Office note. Right. Office note.
नहीं ସେଇଟା ସେ ଆମକୁ perusal କରିଛି
But it is there on the notice of the court. So, notice ଅଛି.
କି नहीं ସେଇଟା ଯୋଉଟା ଦେଖୁଥିଲି ମିଷ୍ଟର ପଣ୍ଡା again
Page 112 में
113 ରେ ଅଛି.
That is a note put up before the joint registrar judicial by the
request of the
and he has requested in criminal appeal section, please do the needful.
And thereafter also the letter to register Odisha High Court.
And page 113 letter to the registrar that forward here with
Closing the order of
এটা 30 তারিখ দিন হতে 30th of November 2024 রে receive it
and
seal tells
the order of the Honorable Supreme Court has also been, it appears from the record that the order of the Honorable Supreme Court has been received by this court on 30th November 2024. Stop. The paperwork has been prepared. Paperwork theory is paperwork has been prepared and the upon receipt for the upon receipt for the learning council for both the parties have also received the paperwork. Placed this matter on 19th of December 2025. Yes. Next.
Item 20.
20 that
can we keep it to the 22nd?
Oh,
yeah. At the top of the list.
ସେଇଟା mention କରିଦେବେ କହିଦେବେ ଏମିତି ଲେଖିଆ
ଆଜ୍ଞା ମୁଁ ଗୋଟେ mention କରିଛି ଗୋଟେ interim bail it is not being taken up item 52 ରେ ଆଜି ଅଛି 3 ସପ୍ତାହ ହେଲାଣି ଗଣି
କଣ ପାଇଁ
the wife is ill she is suspected of having cancer ସବୁ ସେ ନେଇ ଆସିଲେଣି
report ଆଣିଛନ୍ତି
but the matter is going down
day after tomorrow
The report is there now.
and I have to examine 52 though.
Joteswar, Mr. Joteswar.
No, somebody is suffering from cancer.
What is the use of that?
It is that तीन थर mention कर सारे आपण जोड़ा को priority दे आपण mention करछन से matter टा computer ता कोन करछि ना पुराना matter उपु नै जाउछि आ जेते हमें ताको करूछि अवश्य पास ए जो ये गुडा को बेले बेले आसुछि जो लेफ्ट ओवर हे किनी but
नहीं देखो तो
अच्छे yes next
We'll examine the file if not.
All right, by item number 20.
20 my lord.
The last occasion was set for the conduct during interim day.
Yes.
Conduct during interim day. But since the judgment was passed by the Bhanjanagar Additional Section Judge Bhanjanagar Ganja, so we have sent a letter to the jail super Bhanjanagar. But it's come to notice that he is in Sorada. So I prefer some of that.
Report. In the meantime, I have collected the report, custody certificate report, which disclose everything, my lord. Petitioner number 1, the appellant number 1 is in custody for over 9 years as on date.
No, we wanted you are granted interim bail for a period of 3 months.
3 months, sir.
So we wanted your conduct during that interim bail period.
When you are outside.
When you are outside.
Well, this is the report, Lordship. Everything
jail
conduct नुहे
बाहर रिपोर्ट
बाहर जो आपण रहिले 3 मास सेते बेले सेटा रिपोर्ट आईआईसी टू आसीबो से रिपोर्ट अछि जदी आपण पार दियंदा आपण पार भी आसीबो सेटा
ना ना खाली सुपरिटेंडेंट सब जेल
नो सेटा जेल कंडक्ट ए आई यू गेट दिस रिपोर्ट
आज्ञा
the council for the state seek some more time to obtain the तादेर बाय द वे कुहाई थला मध्य कस्टडी सर्टिफिकेट आनिया जोटा कि आपन पार अछि कस्टडी सर्टिफिकेट दे दो learning council for the appellant produce the custody certificate which is taken on record. The learning council for the state have seek some time to produce the conduct of the eta kahar pe appellant number 1 pe
eta 1 pe thila কিন্তু custody certificate पे दे
1 tar कर दे
conduct of the appellant number 1 namely Ranjit Malik, during the interim period. So get it that
Next week.
next week. Yes.
Item 21.
Maybe pardon lordship, I am in BC lordship.
Yes.
The lordship, last occasion direction is given to
That
for taking
conduct
conduct.
during interim well also I prefer next week.
Same for next week conduct as Shani and
Item 22.
IN number 3124/2025.
out of this matter. Next week, we'll do
Again, next one.
Right.
Yes.
Item 23.
Conduct certificate, conduct.
During
Last occasion, there was a motion to the State Council to obtain instruction about the conduct of the offline number 2 and 3.
Yes. 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 Yes.
ନା କଣ ଗୀତୁ
ଆଜ୍ଞା ଛୋଟୁ ଚିତ୍ତରଞ୍ଜନ ପାଢୀ
Ranjan Padi and
ରୁଦ୍ରନାରାୟଣ ସାହୁ।
That it is separate and a separate information.
ଏଇଟା ତ ଜିତୁର
Separate as well.
Itu is someone.
ଏଇଟା ହିଁ ଦେଇଛନ୍ତି। ହଁ ନାଇଁ ନାଇଁ ସିଏ
Chittaranjan and Rudranarayan. 2 and 3.
appellant number 2 ହେଲା ଛୋଟୁ appellant number 3 during interim bail period so and so nothing adverse was found against him. By the way ଏମାନଙ୍କର ये period of detention କେତେ custody certificate
It we have to update.
Installment ରେ ଆପଣ ସବୁ installment ରେ ଆଣନ୍ତୁ।
ସବୁ installment ମାନେ ଆପଣଙ୍କର କଣ ଆଉ କୁହାଯିବ ମାନେ ସବୁବେଳେ ଏଇଟା ଆଇଲେ ରହିଲେ ଏଇଟା ରହିଲା। Most of the bail applications could not be taken up because of this.
How many hearings are going waste, Chief Justice?
ସବୁବେଳେ କୁହା ହଉଛି ଯେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଣିବେ ସିଏ ଟାକୁ ଆଣିବେ ଆଉ ଜେଲ କଣ୍ଡକ୍ଟ ଏଇ ତିନିଟା ଆଣିବେ ଆଉ ଯୋଉମାନେ ବେଲରେ ଇଣ୍ଟ୍ରିମ୍ ବେଲ ଯାଇଛନ୍ତି ତାଙ୍କର କଣ୍ଡକ୍ଟ ଭାଇଲନ୍ ଇଣ୍ଟ୍ରିମ୍ ବେଲ ଆଣିବେ ଡେଲି ଅର୍ଡର ପାସ୍ ହଉଛି ଆପଣ ଗୋଟାଏ ଇଏ କଣ ମାନେ जनरल देवे तांकर 20,000 लेखा पर केस रे बार को एडवोकेट वेलफेयर फंड को आसी देखिए जे ये नंबर 1149 of 2025 there is an application for bail of appellant number 2.3 namely such and such the learned counsel for the petitioner the learned counsel for the state has produced the report dated 8/12/2025 of High Court of Orissa, which shows that nothing adverse is reported against these two appellants. The report is taken on record. However, the learned counsel
One of
for
the conduct is that I may be excused. The custody certificate Jitu and Vishwajit. They are in the.
We are not on Jitu and Vishwajit. We are Chittaranjan and Rudranarayan.
Learned friend wasn't there probably when the leader of the bar was speaking about the phrase that has been put on the rotunda of the United States Advocate General, Attorney General's office. That's why he's behaving in this.
Giving speech and
the learned
ground there
counsel
is a lot of difference.
submits that he may be given some further time to obtain the custody certificate. ଆପଣ ସେ ଫର୍ମାଟ କରନ୍ତୁ ଯୋଉ ଜେଲ ଯେତିକ ଅଛି ତାକୁ ଇଏ କରନ୍ତୁ ଇମେଲ ତାର ରେସ୍ପନ୍ସ ଏତେ ଲୋକ ଅଛନ୍ତି କାହା ଦାୟିତ୍ୱରେ ତାକୁ 2 ଜଣ ଖଣ୍ଡେ ବସାନ୍ତୁ ସେଠି ବସେଇକି ତାଙ୍କ ଦାୟିତ୍ୱ ହଉଛି ଏଇଟା କ୍ରିମିନାଲ ଆପିଲ ତାକୁ ଯେତେ ସିଷ୍ଟମେଟିକ କରିବାକୁ ଆମେ ଚାହୁଁଛୁ ଆପଣ କିଛି ନା କିଛି ଗୋଟେ ଫେଲିୟର ହଉଛି।
See, last time Mr. Parthasarathi Naik appeared. Before that, somebody else appeared. The Honorable Chief Justice has flagged this issue in this thing. Yesterday, he flagged the issue in the public platform. The public platform of this issue is flagged. Still, you are not changing.
ଯୋଉଟା ରହିଲା ଦିଟା ଯୋଉ ଜିନିଷ ଏଇଟା ରହିଲେ କଣଟା କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଉ ଗୋଟେ କଣ ହେଲା ଜେଲ କଣ୍ଡକ୍ଟ ସେ ପ୍ରଡ୍ୟୁସ କରିବେ ବୋଲି କହିଛନ୍ତି ନେକ୍ସଟ ୱିକ ରଖନ୍ତୁ। What about this appellant number 1?
There everything is on record.
ଓ ସେଟା ଆମେ କହିଥିଲୁ ଏକାଠି ଶୁଣାଣି ହବ।
Your lordship wanted to hear.
Right. So ଇଏ କରିଦିଅନ୍ତୁ 22 ତାରିଖ ଦିନ।
Every data meeting somebody else every data.
No, see, the matter day after tomorrow, to the Kamakuri, you, the Bishru, you
50, you have the report. It is 50, you mentioned.
I'll verify day after tomorrow. If not,
Milord, with the permission, Milord. Today item number 3 was there. The cost was imposed 20,000, Milord. Was there. We were thinking of 50,000. Tomorrow I will file the objection, Milord.
No, 50,000 in your presence you would have imposed. Because you are your associate, we imposed 20,000.
You want to increase, then we'll do it.
Now you will record that Mr. Sunatha.
It will withdrawn my submission. Obliged.